lumalaki na. Okay. One, two, three. Wow. Okay. One, two, three.
Hi, Ria. Good morning. Nice to see you. Good morning, everyone. Can I request everyone to please settle down? We'll start in 5 minutes. We'll start in 5 minutes. Ria. May I request everyone to please settle down? We will start in 1 minute. And may I invite our panelists to please stay in front now. Thank you. Good morning, everyone. Welcome to the third and last day of the fourth International Scientific Congress on Private Law of the Philippines and Spain, an interdisciplinary perspective on emerging issues. I'll be your MC for this morning. My name is Ray Paulo Santiago, and I'm heading the Human Rights Center of Ateneo de Manila University. For this morning, our session is on transformative education and capacitating the courts. We have 3 speakers for this morning, and I will be introducing them as they speak. For our first speaker, I'd like to introduce Mr. Peter Tripp. He is the Director of Asia Pacific for the College of Law and the Director of the College of Law Asia. Peter joined the College of Law in January 2005 as Chief Executive Officer and Director of Programs of the College of Law New Zealand. And from 2012 to 2014, Peter was the Director of Practitioner Education in Australia. Since September 2016, he has been based in Kuala Lumpur, Malaysia. Before joining the college, Peter specialized in employment law and managed a large team of lawyers and consultants who advised and represented member employers in employment, industrial relations, and workplace health and safety matters. Peter graduated in Law and Arts from the University of Auckland and began his legal career working in property and commercial practice areas with New Zealand's largest law firm. Other early career roles included an in-house role within a peak industry organization and investigating and resolving complaints in New Zealand's Office of the Ombudsman. Peter's career in industry advocacy and representation and association management includes a senior management role in New Zealand's largest employer organization and CEO roles with 3 national business organizations representing New Zealand's civil engineering construction, grocery manufacturing, and magazine publishing sectors. The College of Law is the largest provider of postgraduate legal education in Australia and New Zealand. Mr. Peter Tripp.
Thank you. It's a pleasure to be invited to the conference. It arose on my very first visit to Manila 3 months ago at a conference to attend the Inter-Pacific Bar Association conference. And Perry Pay, a local lawyer here, is the president of the IPBA this year, and that's why the conference is held there. And he met up with Dean Sedfrey there, and so I got this invitation to speak here about what is happening in the legal sphere in terms of legal education in Australia and New Zealand. And Professor Pedro, lo siento, pero no hablo español. Okay. Just a brief overview of the topics to cover today, a brief introduction about what I was asked to talk about, and then the 3 themes that the paper will cover. One on competency-based learning, which is what we do, a practice-focused applied law approach, and a cloud-based learner-centered technology, those 3 factors that come together. So what I was asked to talk about in terms of the abstract submitted was how we've transformed legal education in Australia and New Zealand, and in the process become by far the largest provider in that area. And those three key elements of the transformation are those three I just mentioned there. But first, need a bit of background and history about that part of the world, which is from Manila. It's 10 hours flying to my hometown of Auckland, so it's not very close. It's a long way away, and many people don't get down that far. But Australia is certainly a bit closer. It's just to cover a bit of the background of how things work in that part of the world. We down there in the far corner there are remnants of the British Empire, and we have an English common law legal system, along with the US and Canada and England and Wales and a few little dots around the place like Singapore and all the Pacific Islands and things like that. So that's the in terms of the basis. Now, what the framework for legal education in our part of the world was all founded on this report to the English Parliament in terms of legal education by a justice of the High Court there. And that report back in 1971 saw the three stages to legal education. The first is a university law degree. Because bear in mind, before, as late as the 60s, people didn't necessarily do a law degree to become a lawyer. They were article clerks and they could go through that process there. So this recognised that you should actually have a formal academic law degree as a starting point, and then a vocational training stage, and then a continuing legal education stage. So that's the framework throughout Australia, New Zealand, Canadian provinces, Hong Kong, Singapore, Malaysia, and to a certain degree in England, but it's a bit different. Now, the Ormond Report was quite a weighty report and very influential around the Commonwealth nations, but there's a few phrases from it that are very important in terms of the work that the College of Law does. And the quote there at the bottom about basically most lawyers deal with a limited range of areas, and they get to know it's all about the fact variation around them. The finer points of law are very well dealt with in terms of academic research papers and that, but that's not what most lawyers spend their daily work on dealing with. So that was recognised in this report back in 1971, and that has been quite an important element in what and how we go about doing things. Basically, the pathway to becoming a lawyer in Australasia is you have that 4-year undergraduate degree. Most people do a double degree in 5 years. Postgraduate practical legal training, vocational training. Then you get admitted. Then you have to have an annual practicing certificate, and you have to have a continuing legal education requirement to maintain that practicing certificate. To the process there in Australia is 11 mandatory subjects for a law degree. In New Zealand, only 6 mandatory subjects that are seen as core. In terms of the practical legal training side, the post-degree practical vocational training, these are governed by 2 separate bodies, and one in Australia, one in New Zealand, and they have various rules and regulations, but the essence about what they do is all competency-based training. So you're establishing competencies and people are meeting those in the training. So that's just a bit about the background to legal education in Australasia. Now I just want to talk a little bit about the college, of where we've come over that same period of time. The college was actually founded in 1974 by the Law Society of New South Wales to establish a course to provide that vocational training. So we're a not-for-profit charitable educational organisation founded for that purpose, but we've expanded across all Australian jurisdictions, because Australia is a federal system with state and territory governments, and New Zealand, and we've now got programs in Malaysia in association with the Bar Council there, the ASEAN Cross-Border Program in association with the IPBA, and the Singapore in association with the Law Society of Singapore. And in terms of innovation, we were a trailblazer in terms of introducing online learning. We, in fact, in 1998, introduced a CD-ROM course to take, that was before the internet days, and we were the first to do that, and we were the first also to do internet training back in 2002. And the interesting thing, observation I want to make about online learning because it meets a lot of resistance around the world in various places. That we do surveys ourselves of customers, and they say they prefer 90 to 10 to do face-to-face courses. But when they come to choose what they're actually going to do, they prefer 95 to 5 to do an online course because it's more convenient and more effective way of doing it. So, and I'll come to this a bit later on, but in 2014, we made the decision to move to a cloud-based learning platform. And I'll cover that a bit more later on about the benefits that brings. Now, basically what we do as an organisation is to support legal careers through all the levels that they go, so right from the career foundation through to specialisation. That's just the categorisation of our programs there. And just a bit about the numbers there. We've got 63% of all Australian law graduates, 66% of New Zealand. And in the space of 10 years, starting our master's program in 2008, we become in that short space of time, and there are 35 law schools in Australia. We've become the second largest master's degree provider in the nation. So that the message from that is that what people are looking for outside the traditional academic master's degree, which a lot of people do for academic purposes because they seek a career in academia or for other career, is that they're looking for something that enhances their career through providing them with the skills they need in a particular practice area. And so that's the key focus of why it's been a successful approach to what lawyers are looking for in terms of postgraduate qualifications. Now the next part is just to cover briefly about the competency-based learning that underpins all of what we do. And I've got a couple of examples here. So we've used the same process in our master's programs of having a competency-based approach to setting out the subjects and what people do in them. So looking at the PLT competencies in Australia, they fall under 4 parts: skills, compulsory practice areas, optional practice areas, there are 8 of them, you choose 2, and values on ethics and professional responsibility. Now I've got just a couple of examples from the standards that illustrate how they're done. So the general descriptor, an entry-level lawyer should be able to demonstrate blah, blah, blah. And then there's 8 elements then of what they need to be able to do, and there are 29 criteria within that. So it's all spelled out. At the end of the day, the person assessing that student, that lawyer, has to be able to say that they've competently achieved the tasks that are being set out in that criteria. Here's an example from property law practice. What an entry-level lawyer should be able to do. Pretty standard. And again, 5 elements and 14 criteria to meet. And just an example of an element there, creating leases. So at the end of that process, the lawyer knows how to do those tasks. So that same philosophy was applied to the master's subjects that we do. Of course, at a higher level on the qualifications framework and building in what's needed to comply with those areas there. But basically, when we set out creating any master's course, we look for an expert in the field, a practitioner expert, and ask them what are the essential things that a person needs to know how to do in this particular practice area, and you build from there. So the whole subject is built around, well, this is what they need to know how to do. So you build activities and tasks around learning how to do that activity. And it basically enabled us as a college to create a course creation template process, which makes it easy for us to adapt our content and our way of doing things to any jurisdiction. So across all Australian jurisdictions, New Zealand, Malaysia, Singapore to come, and of course the cross-border thing. So that's just a overview of those there and the practice areas. I won't dwell anymore. That's just a bit on what's in the program. The other feature just worth mentioning is that in terms of, there's the modular structure of mergers and acquisitions practice in an ASEAN context. Each of these, of course, are being offered as professional development units. So people can get micro-credentials around them and badging and all those sort of things that contribute to training, but not necessarily for people who want an LLM. Now finally, the final section on the learning-centered technology, a brief look at the teaching methods and the technology. Basically, our focus is on having practitioners write courses and teach them, and they inform the whole process of how we develop and teach students, so as opposed to an academic focus. And fully mobile, available anywhere, anytime, on any device. So it's a structured program, interactive, monitoring with a mentoring rather from a lecturer. Feedback we get is that people find that the one-to-one relationship they have with a lecturer online is far better than what they get in a class environment like this. Teaching methods, we've got this approach of information, demonstration, application. So a three-step process for the learning process of how people engage with the information, showing how they should go about doing it, then of course doing what they've been told how to do. And the lecturer feedback is a very one-to-one from the lecturer through the learning platform. Excuse me. They can reply via video, audio, or through a very comprehensive document review process. We have all the tools available to comment and write upon the documents that have been submitted. WebEx conferences are synchronous once a week, and everything else is asynchronous. Assessment, the portfolio work, the written assessment, and an oral assessment at the end. In terms of the information technology, the final point to finish on is that, as I said, this decision, and we were quite early in the field of going to the cloud back in 2014 in terms of getting there. The Salesforce is a CRM, Canvas in structure, very sophisticated mobile learning platform. The best thing about this whole approach is that you can buy just like an app on your phone. You can get an app off the App Exchange and have any tool that somebody's created and just plug it into your learning methods, just like that. No need to integrate or problems integrating that or whatever. It just happens, just like it does on your phone. And it means it's scalable, no matter how many students you've got, wherever they are, adaptable, and you've always got the latest technology. So that I've got ahead of myself, so I finished time. We operate, as I said, across around Australia and New Zealand, and we've just recently started in Asia. We've got 3 relationships with the Bar Council, the IPBA, and the Law Society of Singapore in terms of memorandum of understanding. So I'll conclude on that. Thank you.
Thank you, Peter, for your presentation on transforming legal education in Australasia. The next speaker will talk about the law school as a pedagogical space for ethical formation, the Ateneo Law School experience. The next speaker is Professor Tanya Karina A. Lat. Professor Tanya Lat is the Program Officer for Formation at the Ateneo de Manila University Law School, where she has been a faculty member since 2013. Professor Lat teaches legal profession, legal technique and logic, legal ethics, and the elective, the lawyer as leader and policymaker. As a law professor, she is keenly interested in developing lawyers as ethical practitioners, leaders in society, and active agents of social change. Her goal is to create a cadre of lawyers who are committed to spirituality, social justice, and personal and social transformation, towards the creation of a just, inclusive, and humane society. She teaches mindfulness meditation as a tool for stress management and introspection in her classes. Professor Lat has taught at the Political Science Department of the Ateneo de Manila University, at the Far Eastern University Institute of Law, the Polytechnic University of the Philippines College of Law, and the San Beda Graduate School of Law, and has delivered occasional lectures at various law schools all around the Philippines. She is a consultant to the Legal Education Board of the Philippines, where she is involved in initiatives to review the Philippine law school curriculum and mainstream conflict sensitivity and conflict transformation in the legal education. Professor Lat holds a Bachelor of Science in Psychology degree from the Ateneo de Manila University, a Bachelor of Laws degree from the University of the Philippines, and a Master of Laws degree in International Legal Studies with distinction from Georgetown University Law Center. She was admitted to the Philippine Bar in 2002. Ladies and gentlemen, Professor Tanya Lat.
Thank you very much, RP. And a pleasant morning to everyone. Buenos dias to our Spanish visitors, and magandang umaga sa inyong lahat. My presentation this morning is about the Law School as Pedagogical Space for Ethical Formation. And I'd just like to give a brief context of this. I'm currently ending actually my fifth year here at the Ateneo Law School and completing my fifth year of teaching. And this paper is actually an opportunity for me to synthesize and integrate the things that I have been learning and thinking about these past 5 years. I'd like to thank in particular Dean Cedric Candelaria, who recruited me to the faculty. It was because of him that I'm here on the faculty, and he gave me specifically the portfolio of formation to think about how can we form our students better. And he gave me subjects such as legal profession, legal ethics, and the chance to teach an elective called Law and Leadership. And so what I'm going to be sharing with you today are my insights and thoughts on the teaching that has happened in the past 5 years, and perhaps food for thought for you on how we can collaborate in the spirit of creating lawyers who are ethical and committed to a just and humane society. I'd like to start out first with this article. Some of you might have heard of it. Patrick Schiltz is an American lawyer, and he authored this article called On Being Happy, Healthy and Ethical in an Unhappy, Unhealthy, and Unethical Profession. And I give this to all my students, whether they're freshmen, sophomores, or upperclassmen, read this. This is part of the first set of readings. And it gives them an insight as to the kind of profession that they'll be entering. And I think the laugh of recognition from the Spanish and Kiwi counterparts shows that it is not just unique to the American setting, but also to the Philippines, New Zealand, and Spain. And Patrick Schiltz talks about 3 layers of ethical behavior. The most basic and the lowest common denominator is following the ethical rules. No-brainer, you can get disbarred or your license can be revoked if you violate the rules of professional conduct. But that is the surface. Basically, you just don't break the rules, or if you break the rules, don't get caught. Okay, definitely that's not where we want to stop. He goes on to a second level of being ethical at work. But here you make a distinction between professional behavior and ethical behavior. It's possible that you're a really, really good lawyer, very competent, you're very ethical, but you cheat on your wife or you have mistresses on the side, So again, you don't want to stop at that. Patrick Schiltz tells us that ideally, all of us, all lawyers, should try to aim for integration between our professional and personal lives. And therefore, the goal, ultimately, is to live an ethical life, whether you're practicing or whether you're at home with your family or relaxing on the beach. The ideal is that you're an ethical person, both as a lawyer and as a human being. And so one of the questions I've encountered and continually think about in the course of my teaching is, why is it that despite professional codes of conduct, so in the Philippines we are governed by the lawyer's oath, the Code of Professional Responsibility, the rules of court, and different cases ruling upon the different rules, and you'd think that with the same set of rules we'd all end up ethical, right? Okay, but as you know, there is still incidents of unethical behavior. People engage in illegality. Right now, we have a current culture of impunity, sadly. And you have lawyers behaving out of self-interest instead of the interest of the client or the interest of justice. And so, perhaps there's something in the middle. You know, what is it that's moderating the behavior? What is it that's mediating between the code of conduct and the desired behavior? So another way of framing it is you have an event, you have a dilemma, and then you have the behavior. You have how the person acts in accordance with that particular event. And so why is it that with the same event, the same dilemma, people confronted with the same issue, you have the same set of rules governing? You have people responding differently. And so what accounts for that? In the UK, there's this reminder when you go on the train to mind the gap. And so I think it is this gap in between the event and the behavior that determines the kind of choice that people make. What happens in the gap between the dilemma and when we take action on that particular dilemma? There are two particular possible responses. Okay. Well, first is the reaction. A reaction is instinctive. It's generally unconscious. It's knee-jerk. It's gut. It's spontaneous. It's usually done without thinking. And it is characterized by Kahneman, if you've heard of the book of Thinking Fast and Slow. Okay, so these behavioral economists looked into the two kinds of thinking, and there's what is known as Systems 1 thinking. Systems 1 thinking is instinctive. It's unconscious. It bypasses the rational brain. It's believed to originate from what is called the reptilian brain, the most primitive part of our brain that is programmed either to fight, to flee, or to freeze. So the survival instincts are typical Systems 1 thinking. And so when you're hungry, it's usually Systems 1 thinking. You will consciously reach for that can of soda. Perhaps if you're thirsty, or you'll reach for that bag of chips. Okay. The other way, the other behavioral response is the response. And the response is conscious. It is rational. It is deliberate. It is thoughtful because it requires some thought. It's not knee-jerk. It's something, you have a certain pause before you actually do something or go ahead and say something. And this is known as Systems 2 thinking, which is the higher level of thinking. It's called executive function. It involves a higher, more evolved part of the brain, but it involves more energy and is more difficult to undertake. Okay, between the two, our default is usually Systems 1 thinking. We react, we don't respond. And so here are the different factors that affect one's choices, and it can be depicted as an iceberg. As we know, icebergs, most of it is below the surface. What we see on the surface is conscious and overt. So this is the behavior. What happened? Did he lie? Did he pad his billing hours? Did he tell a half-truth to his client? You know, that is what is seen overtly. But also, it can also be characterized as something that is conscious and deliberate. It's not knee-jerk. It was something that was premeditated or thought of. However, there are many factors that actually happen below the radar of our consciousness. What is subconscious or hidden? Okay. One of this is culture. We live in a culture, we are immersed in culture. There are certain ways of being, of thinking, of doing that are unique to us. One of the things I do, one of my first classes in legal ethics, I give them a case study which shows Philippine culture at work. We have certain unique characteristics, certain ways of behaving. And interestingly enough, I give the case study to the students, and I ask them, what are the ethical dilemmas in this particular case? Half the class sees it, half of them don't. Okay, and so it sparks off a very, very interesting discussion about the role of culture and how it shapes our behavior and our values. The second is the importance of context and environment. Similar to culture, the environment, the people who surround us, the people who influence us, the pressures in a particular situation, they influence how we behave. And taking all of that together, the culture, the values, the context, and environment, you have an underlying system and structures which ultimately shape our ethical behavior. And I'm currently reading this very, very interesting book called The Lucifer Effect by Philip Zimbardo. Understanding how good people turn evil. For those of you who don't know, Philip Zimbardo was the author of the famous or notorious Stanford Prison Experiment. where they brought together normal college students from Stanford. They were pre-screened for whether they were psychologically disturbed or normal, you know, and all things being equal, they were all pretty normal American boys. And the experiment showed that in a particular system that they created, when they created a prison system, simulating the conditions of a real prison, they found that the only thing that made the boys different was the determination that some of them would be prison guards and some of them would be prisoners. And in the span of 5 days, 5 very, very short but excruciatingly long days for those who were in the experiment, showed that good people can turn evil because of a system. Okay, so it's important for us to understand that the system influences us. If we ignore it, we pass up the opportunity to influence the system. Okay. And then aside from that, there's also the inner state of the person making the decision, the inner condition. Sometimes the inability to make ethical decisions is not really a conscious choice. Sometimes it's born out of stress. Sometimes it's laziness. I don't want to think anymore. Sometimes the feeling of learned helplessness. I don't have a choice. I don't really have a say in the matter. Perhaps it's a sense of irrationality. Sometimes it's simple hunger. Many psychology books will tell you that one way to improve your chances of decision making is to boost your sugar level. Chances are when you're hungry or you're stressed or you're tired, you will make poorer decisions than if you were well-fed, rested, and happy. Okay. Also, one inability to make ethical decisions has to do with the inability to reflect. Okay, and so questions to ponder here, how do we develop a person's instinct to act ethically? Second, how do we slow down the process to create a psychological space to think before acting? Third, how do we develop a person's inclination to choose to do the right thing? And fourth, are creative choices possible? How do we create the space for creativity? Okay, and these are questions that we are continuously asking ourselves and trying to answer in the course of our teaching here at the Ateneo. So what are we doing here in the classroom as a law school and as a university? Okay. We remind ourselves that our identity is we are a Filipino, Catholic, and Jesuit institution. We are a law school, but we also operate within the larger frame of the Ateneo de Manila University. And so these changes over the past 5 years have coincided with a thrust on the part of the university in general to undertake formation as a conscious, deliberate effort, to involve our students in greater greater nation building, and also to form our students to be more thoughtful, reflective, and ethical. So as a law school, we envisioned graduates who are not only skilled in the science and art of the law, but also leaders who are imbued with a burning passion for justice and the desire to serve the nation for the greater glory of God. Now, how does this operate? You know, all these very lofty ideals and vision. Here are some of our current initiatives. We're innovating how we teach legal ethics, and I'll go into that in a little while. We have instituted an integrated formation program where we look at the whole person. Part of Jesuit education is what is known as cura personalis, care for the whole person. And so with this integrated formation program, we don't look only at the academics, but we also look at the psychological, the spiritual, and the social components of being a student here at the Ateneo Law School. We encourage our students to go outside the classroom, so there's exposure, there's immersion. My second-year students will be going on apprenticeship this summer. There is what is known as clinical legal education, where we have students who undergo practical legal training, similar to what is done in Australia and New Zealand. Before they go out and practice law as lawyers, they have a chance to practice as law students who are authorized to appear before the courts. We are also looking into mental health and well-being. Mental health is a big issue here in the Philippines and also around the world, as I suspect, brought about by the rise of technology. And our students have actively asked us for assistance in dealing with issues like anxiety, depression, and suicidal ideation. And we also have a class advisors program. This was instituted by Dean Said. He jump-started an existing program and made the advisors more active partners with the students. We meet with the students at least twice a semester in a so-called homeroom program where we basically ask them how they're doing. And they can ask us about matters relating to career, as well as psychological, social, and sometimes spiritual matters. So some assumptions that we are re-examining in the course of our teaching. Okay, some people think that it's too late to teach ethics in law school. You either have it or you don't. Okay, what's the point of teaching, right? Okay, but we believe that one's ethical foundations can be reinforced or undone in law school. And as all of us know, all of us who've gone through law school, the law school journey changes you. Who you are in second year is no longer who you were in first year. Who you are in fourth year is no longer who you were in second year. Okay, so we are continuously changing. True, they don't come to us as a blank slate, but there is a chance for us to still mold them or to at least bring them to the right path. From my own experience, most of the students who come into my classroom as freshmen are very idealistic. And then when they go to court, I ask them to observe court proceedings. You know, they will come back to class saying that they were very disturbed by certain things they've seen in court, or they were inspired by judges who were very professional, lawyers who were really on top of their game, you know. And so we want to capitalize on that idealism. The cynicism has to sink in first, and we try to expand and lengthen the time of idealism as long as we can. A second assumption is that it is enough to know the rules. But from our own experience, knowing the rules of ethics is not the same as applying them. Okay? It's one thing to know the rules, it's another thing to actually apply them. And then it's necessary to understand the underlying factors, that iceberg that I showed you. We have to surface the unconscious so that we can influence the conscious. And ethical decision-making is a life skill that can and should be taught. And this is something that we are trying to teach in our classrooms. Now, some of my insights on teaching legal ethics. One is the methodology matters very much. Conversational learning is something that we are trying to do in our classroom. And for our foreign visitors, here in the Philippines, the default mode of teaching is either the Socratic method or the lecture method. And for those of us who've gone through the rigor of the Socratic method, we all know how harrowing that can be. You are graded. If you fail to answer within the next 5 seconds, you may sit down and you get a grade of 60 if you're lucky. You know, so it's not very conducive to ethical conversation. Thomas Kohlberg, the famous moral psychologist, he believes that moral development is best done through conversations, and you can only do that in a space that is safe, where it is conducive for people to talk freely without fear of being judged. Second is we teach an ethical decision-making tool. There's a step that was, there was a tool developed by one of our ethicists, Dr. Antoinette Palma Angeles, who teaches at the School of Philosophy, the Department of Philosophy. And she also has cascaded this tool to us. And I currently teach it to my students. And after this conference, this afternoon, I'll have a series of oral examinations with my students. And it's interesting to see how they apply the tool. Basically, we give them a situation, and then they have to apply the tools where they look at things very methodically, step by step. And from yesterday's examinations, my students told me that, "Ma'am, this is very helpful. We're going off to apprenticeship in the summer in a few weeks. And the decision-making tool has helped us become methodical about how we look at ethical dilemmas. It's not just black and white. We look at the factors, we look at the competing values, and we look at the possible consequences of these courses of action." Okay. And then the third thing that we do is we cultivate a habit of reflection and introspection. As RP mentioned in the introduction, I teach meditation to my students. And I purposely do that. I sacrifice 15, 20 minutes of my class time in order to teach meditation. But it really changes the buzz in the room. It's very difficult to compete with big subjects like constitutional law, property. It's a losing game if you're teaching ethics. You know? So first thing I do is I try to schedule my classes on the day where I don't have to compete with them. But if I have to compete with them, I know that if I change the mood with meditation, things will be all right. So sometimes they come into the room, they're all anxious, they're all stressed, or maybe the class comes after, and so they're thinking ahead already, they're worried. 5, 10 minutes of meditation, and we reflect. I ask them how they are after. After that, they're calm, and we can have a rational, decent, fruitful conversation. Okay, so meditation is very helpful. So I see now that my time is running out, but some things just in passing. I don't recommend the Socratic method for ethics. I recommend collective learning in groups. It's very effective. We come to the classroom assuming that everyone has a set of beliefs and everyone can be a resource person, and we value the collective. And I've seen that students learn very well if they work in groups, especially if they're among friends. And they have very, very animated discussions. I'll bump into them in the cafeteria, and sometimes they'll tell me, "Ma'am, what do you think of this case?" And they're discussing something that is assigned to them for class. The ethics case studies that we use are Harvard-style business case studies. So it's not the cases already decided upon by the court. These are cases which are open-ended. And so there's a lot of room for discussion because nothing has really been decided. You can't cite the Supreme Court. You can cite the Supreme Court, but they haven't exactly decided on exactly the same thing. So you have very, very animated discussions. Okay. And what is very important is that we create and cultivate safe spaces for dialogue and conversation. And so sometimes during meditation, we're supposed to be reflecting on ethics, and someone tells us about what happened to him and his girlfriend. They broke up, or something that's going on in the family. And it's unexpected, but it's important to them. It affects their mood, it affects their decision making, and so it has to be discussed. And so, you know, I consciously sacrifice time to discuss something that's important to them. Okay. There's so many other things that I want to share, but there's also an annual legal ethics symposium that we do. We've had it for 5 years running. It's always something that the students organize, and it's always very interesting to them. This year, we discussed something about social media, how social media technology are influencing legal ethics, and we had a very, very animated discussion, and we even had guests from other law schools come because it was such an important topic for them. So I will just move down to my last few slides, and reflection and introspection are very important, so we encourage them to meditate, to keep a journal, and to reflect on their experiences. Professor Antonio talked about the role of cinema in his teaching, and one very powerful movie that I recommend if you teach ethics is Bridge of Spies. Yeah, Tom Hanks, James Donovan, wonderful, wonderful case. It conveys so many, many rules in one movie, a wonderful movie to watch. So I highly encourage that. Okay. And we continuously ask ourselves why. Why do we do this? Why is this rule here? What is your purpose for being a lawyer? Why do you want to serve society? And their sense of purpose is very important in keeping them idealistic and keeping them grounded as to why they want to become lawyers. Okay. And so the Integration Formation Program, I'll just show you some slides. Basically, we help them discern their career. We help them determine how they intend to serve, and we want to aid in their spiritual formation. So it's a ladderized program where every year they try to answer a particular question. So starting out with whether law school is for them, where will they apprentice, where would they choose to specialize in, and hopefully by the time they get to 4th year, they already have more or less an idea of where they want to go. We also expose them to sectors and issues outside of the classroom. We encourage them to go out. First year, I encourage them to go to jail, not as inmates or convicts, but to visit. Okay. In my own experience, as a formator who went to jail as someone being formed, it was very informative for me to realize the sense of helplessness. When they go to jail, they have nothing to offer when they're in 1st year. They don't know the law, they just have very basic understanding of the rules. But they go there with an open heart, with open eyes, hopefully, and then they come back transformed. They say, why is the justice system like this? This person has already been in jail longer than he should have been, you know, and it changes them. And I've seen some people who were so deadbeat in my class, you know, the people who sit at the back, who don't listen, who are just tweeting or Facebooking. After the jail visit, they were all attentive, they were all eager to share, they were all eager to participate, and they said, "Ma'am, I'm not quite sure if I want to be a lawyer, but I know that what I saw in the jail should not continue." You know, so the power of immersion, of experience, can really transform people's perspectives. Okay. And lastly, how do they develop their relationship with God? We have instituted mandatory recollections and retreats. And even though the students think they don't know it, they don't need it, when they finally go through it, they said, "How did you know that we needed this?" Okay, so the people who usually think that they don't need retreats or recollections, they're the ones who really do. Okay. And so, just in closing, things that I would like to see, and these are frameworks that educators could use. First is outcomes-based teaching and learning. We need to be very deliberate about how we teach and how we convey information to our students. So we need to begin with the end in mind, as Stephen Covey said, and we have to align our programs, our teaching methods, and our syllabus and content to the outcome that we want. There's a concept known as constructive alignment. The authority on this is Biggs and Tang. There's a wonderful ebook on it. Again, you have to constructively align everything in the law school using a whole school approach. It's not just the role of the teachers. The support staff play a role. Student activities play a role. And more importantly, the policies instituted by the dean and the collective culture and environment that you cultivate in the law school shapes our students' behavior. One thing I'd like to leave you with is when I came into the law school, so I came in as an outsider because I came from the other law school. So, you come in with a different set of eyes and you see certain things that other people don't see. And when I came in, we have what is known as an orientation seminar program where the second-year students orient the incoming freshmen. And the themes, they choose the themes. The themes before were Survivor, Hunger Games, so it's like survival of the fittest, that kind of thing. And then I was privileged to have one batch of students that said, we don't want this to continue, enough is enough. So the following year, they decided, instead of Hunger Games, we will do high school musical, law school musical. So total shift. And then you had Tahak, Journey, Ad Astra per Aspera. So something that's more lofty, less competitive, more nurturing. And that came from the students. It was something that came directly from them. And it's now being complemented by certain policies that we're instituting here at the law school. And so ultimately, we want to see a shift in the culture from a law school that's very competitive and cutthroat to a law school that's very nurturing and very caring. And so as they say, it takes a village to raise a child. In the same way, it takes a community to form ethical lawyers. So with that, maraming salamat po. Muchas gracias.
Thank you, Tanya. I know it's very difficult to keep it to the 15 minutes for all our speakers. Very interesting presentations, but I'm sure that you can get a copy of the PowerPoint presentations later, and a copy of the paper will be made available. Our next speaker will talk about transformative education and capacitating the courts, perspective from the Philippine Judicial Academy. It will be presented by Justice Adolfo S. Ascuna. Justice Ascuna is a retired Associate Justice of the Supreme Court of the Philippines and is the Chancellor of the Philippine Judicial Academy. He received the degree of Bachelor of Arts with academic honors at the Ateneo de Manila University in 1959 and the degree of Bachelor of Laws cum laude at the same institution in 1962. He was admitted to the Philippine Bar in 1963, placing fourth in the 1962 bar examinations. In 1982, he completed postgraduate studies in international law and jurisprudence at the McGeorge School of Law in Salzburg, Austria. And on October 17, 2002, he was appointed Associate Justice of the Supreme Court by then President Gloria Macapagal Arroyo. In 2007, Justice Ascuna was conferred by the Metrobank Foundation Professorial Chair in International and Human Rights Law, and in 2012, he was the first recipient of the Founding Chancellor Emeritus Justice Amarfina Melencio Herrera Award for the most outstanding professorial lecture, and in 2013, the Junior Chamber International Senate Philippines and the Insular Life Assurance Company conferred to Justice Ascuna the Outstanding Filipino Award for 2012 in the field of justice and law. He was elected by the International Commission of Jurists as one of its 5 new commissioners for a term of 5 years, from 2014 to 2019. In 2016, the Ateneo de Manila University, during its traditional university awards, conferred Justice Ascuna the highest award, which is the Lux in Domino Award. Justice Ascuna's major publications include International Sales of Goods, Transnational Law Practice, International Law Teaching in the Philippines, Doing Business in the Philippines, Foreign Judgment Enforcement in the Philippines, Piercing the Veil of Corporate Entity from Willits to Santos, ASEAN Conflict of Law, the Supreme Court and Public International Law, and his 2 Supreme Court books, Seeing reality in today's world and seeking justice in today's world. He was also a guest speaker at the International Scientific Congress on Private Law of the Philippines and Spain last 2016 here at the professional schools, where he presented a paper on the constitutional function of human rights principles within the context of private law in the Philippines. Ladies and gentlemen, Justice Adolfo Ascuna.
Thank you very much, Attorney Ray, Paulo, my student, Honorable Dean Cedfrey Candelaria, the chairperson of this Scientific Congress, Honorable Jose Manuel de Torres Pereira, the vice chairperson of this Scientific Congress, sus señorías, honored guests, friends, ladies and gentlemen, magandang umaga po sa inyong lahat. Buenos dias a todos. I am privileged to present the Philippine perspective on judicial training. But before I do that, I'd like to acknowledge PhilJA's presence here. The Philippine Judicial Academy is strongly represented. Please stand up from PhilJA. The reason why they are here is because Dean Candelaria is their boss in the Philippine Judicial Academy. Thank you. The School for Judges in the Philippines is very much like the School for Judges in Spain, which I had the privilege of visiting a few years ago. In Spain, this is for our judges. Their School for Judges is located in two places. One in Barcelona and the other in Madrid. Why Barcelona and Madrid? That is to political move to bring in the Catalans to the judicial system. But it is run by a constitutional body called General Council for the Judiciary, Consejo General del Poder Judicial, constitutional body running the Escuela Judicial, the School for Judges, which has two branches, Barcelona and Madrid. In Barcelona, basic training for those who want to be judges, basic muna. And after they become judges, continued training in Madrid. In the Philippines, both basic and continued all under one institution, Philippine Judicial Academy. In Spain, before you become a judge, you have to take a very difficult exam, public exam. Only very few pass it. And they only admit to their school in Barcelona exactly the number of vacancies. If they have 100 vacancies only, they will only admit 100 students. So all the students are sure to pass because they have to fill the vacancy. But they have to stay for very rigorous training of at least 9 months, sometimes 1 year, theoretical and practical. After that, they take an exam, and then they go into internship with a real judge and participate in the work of the judge for another 9 months. Then they come back to Barcelona. And their grades given by the judge and their grades in the academy are combined. If they pass, then they get their certification, their license to be a judge. And it is in their graduation, the king himself gives them their assignment as a judge, their appointment. That is how important judges are in Spain. The king himself is the one that gives them their credentials. After they become judge, continuous training in Madrid. And I learned from them, they have this Plan Estatal, state plan. At the beginning of the year, all the courses are there already, listed and put online. The judges don't have to attend. It's all optional. But if you want to attend, you choose what you want to attend. It's already there. Who is the professor? Where is the classroom? and the number of students or judges admitted for that class. I saw this number 35. What does que quiere decir? 35. That's the number of the participants. Once you reach 35, we close it. So you have to be fast if you want to learn about computer, like what Maribel talked about, Judge Maribel, professor from Spain. You have to list right away before it closes. So when I came back, I asked our academic affairs head, Justice Delilah Vidalion Magtoles, can we come up with a plan at the start of the year? Our plan is only 2 months ahead. So we did. Now we have also a yearly plan so that our judges can prepare and already schedule their cases because they know what the training dates are. But our trainings are mandatory. So I'll tell you about the Philippine Judicial Academy. It is the unit of the Supreme Court of the Philippines. And the Academy was first organized by the court itself through an administrative order in 1996. How do you operate this gadget? That is technology. We are now using technology to teach judges. This is called interface between technology and learning. Created by administrative order in 1996, then followed by a legal charter, Republic Act 8557, passed in 1998. So we have a charter. And the charter says that it has to be the arm of the education arm of the Supreme Court, and it has to be headed by, ikaw na lang. It has to be headed by a retired justice of a collegiate court. That's why I'm the one heading it, because I retired in 2009, and 2 months later I was appointed to head. And a two-year term, I have been renewed 4 times. The governing body is a board of trustees, and the head of the board of trustees is the Chief Justice. So there is built-in support by the Supreme Court to the academy, which is not true with academies all over the world. Of course, in Spain, they have the Consejo General, which is the constitutional body that is, the school is attached to that. So there's built-in support for the school. In other jurisdictions, their academy is separate from the courts and may or may not get support from the court. So that is the problem. Here we have built-in support, chaired by the Chief Justice, and the members are from academe as well as from the 3 highest courts of the country, tasked with formulating policies regarding the training of judges. Next slide. Okay, that's the organizational chart. I have the Chancellor, I have Vice Chancellor, Justice Callejo, also retired Supreme Court Justice. Executive Secretary, Marina Buson, retired Court of Appeals Justice. Then we have divisions, finance, administrative, academic affairs, research and publication, headed by Dean Candelaria, and mediation office, and our training center in Tagaytay, 50 kilometers away from here, near the volcano. This is the only place in the world where you have an island and a lake, and an island and a lake and an island. That is Tagaytay. So we have a 4-hectare facility there that used to be a sports club, but was taken over by the government when it was not able to pay its loan, and the President Ramos gave it to Supreme Court for training site. And many of you perhaps have gone there. I think Professor Angel Rodriguez has been there. And it is a very modern type of facilities. I was the one who finished it. It was started by my predecessor, Justice Herrera. I finished it in 2010. And it has even board and lodging. But you have to ask my permission to have drinks after the Yes, because the civil service prohibits alcoholic drinks either in the place, public place, or during office hours. So if it is private place but office hours, no drink also. So Tagaytay Training Center is public place. Even after office hours, you have to have permission of the head of office. So our general manager always texts me, can they have social drinks tonight? Yes, approved. The heart of the Philippine Judicial Academy is Corps of Professors, which is appointed by the court itself. We recommend, the Board of Trustees recommend, the Academic Council recommend, Supreme Court and Bank approves the Corps of Professors. And Professor Balane, who is your friend, is our head of the Civil Law Department and has been so for many years. So you can see we have a very strong Civil Law Department. That's our academic council. We meet every month and we design the curriculum of the academy, and that's our mandate, really to train. There are 3,000 judges in Philippines, both first level court and second level courts. That is the trial judges, the frontline judges. And we train them. We get to train them, almost all of them, throughout the year. We have 4 regular enhancement courses and 80 special programs, from gender sensitivity to decision writing to personal security, how to shoot with a firearm. We train them, and the Chief Justice usually takes part also in the target practice. So 80, that many, and all mandatory. And that's why they are complaining. We have no more time to try our cases. We are always studying in PhilJA. So we will go into online training now because we learned from Peter. We have online training. So we will design our lessons so that you can stay in your court and study online. These are the different dispute resolution mechanisms, ADR. The CAM, or Court Annex Mediation System, Australia has this, is debated in Australia whether they should have or not. Meaning that all cases, filed civil cases, must first, after filing, be referred for mediation or settlement by a trained mediator under the supervision of PhilJA. So we have a system of mediation under our supervision, Court Annex. We have field units all over the country where mediators are attached. And success rate is very high, 67%. The Asian average is about 35%. Philippines, 67%, meaning 67% of our cases don't have to be tried. They are settled, and it declogs the court. So it's a very good system. These are our programs. As I said, we have 80 programs. We train them from the time they want to become judges to the time they are already judges. PhilJA trains them. There are 28,000 court personnel, including judges. And PhilJA trains not only judges, but even sheriffs, clerks of courts, stenographers, social workers, all kinds. As long as they are with judiciary, we train them. We even train prosecutors who are not with the judiciary. In the Philippines, prosecutors are with the executive department. But they don't have a school for prosecutors, so they study under us. But COA does not approve the expense. COA are very strict. No. Under the law, you are supposed to train only court personnel. Prosecutors are not court personnel. Therefore, your funding disapproved. So what we do, joint funding. If we have joint training, joint funding, approved by COA. Okay, so we have these different programs, special lectures, special focus. One time I introduced LGBT training, LGBT. And then it was very well received, LGBT. So this is our technique of delivery. face-to-face as well as starting now e-learning. Okay, this is the linkages of Dean Candelaria website. We have a nice website. You can see the rest of my speech in the website and other there. Materials, we adopt the outcomes-based education, similar to competency-based training. And we are happy to inform you that last year we hosted the first International Organization of Training Institute, IOJT, worldwide conference, the 8th, here in Manila, in Makati, very successful, ended with a declaration of Manila on judicial education. And these principles are being followed now by all judicial institutes who are members of IOJT. There are more than 100 of them. And basically, it should be judge-led. Judicial education should be judge-led. Not exclusively, but leadership should come from the judiciary. Our judges are sensitive. If non-judges teach them, they are sensitive, especially if they teach them how to run the courts. So non-judges will have to teach them on something they don't know, like how to turn on the computer. Okay, so I close by an observation. In Spain, law is derecho, no? Derecho. And right is also derecho. Okay. In France, law is droit, and right is also droit. In Germany, law is rex, and right is also rex. In Philippines, no. Right is canon, but law is batas. Why is that? Figure it out. Thank you.
Thank you very much, Justice Escuna, especially for the last thought-provoking question about the difference. We have 30 minutes for our open forum. We have the microphone in the middle. Please go to the microphone, introduce yourself, and you can address the question to any of our panelists. We'll have a first round of questions and interventions, after which we'll ask our panelists to respond, and if we still have time, we'll have another round. Yes, sir, please do so. For those who would like to intervene, I now invite you as well to please, you can line up in the middle.
So, good morning, esteemed panelists. My question would, I am Jose Rafael Bartolome from the College of Law, and I'm a graduating student. So, it is quite obvious that my question will be for Professor Lat, given that I'm a student. So, allow me to give a background of my short background of my journey in law school and how my mind came to be right now.
And kindly keep it short, sir.
Yes, of course.
Okay.
So I started law school. In our orientation in my school, I told myself, and when they asked me what I wanted to become a justice of the Supreme Court someday. But as I journey to law school, as I go to the harrowing experience of law school, of facing different professors, of facing different struggles, like having a child or whatsoever, my idealism started to dwindle, especially since I don't want to sound contemptuous, especially since our government is experiencing very, very harrowing struggles and challenges right now in the judiciary, in the legislative, and the executive, especially the executive. Now, I'm just telling myself, what's the point of becoming an ethical lawyer? What's the point of having the heart to serve the people if you see those people who are supposed to serve you are actually breaking you piece by piece? Now, I have 3 questions that are interrelated for you, Professor Lat. First, of course, is it too late for me to reconsider my stand and to become an ethical lawyer and have this fire burning in me? And next, the systems that you have imparted to us earlier, would they be plausible to apply them to other fields of law, and in that other professors would apply them in their field of study to produce more effective lawyers and to have more learned students? And lastly, will becoming ethical help me in my bar exams? Thank you.
Thank you. Any other interventions, please? Okay, hearing none, let's hear from Professor Lat. And thank you for breaking the ice.
Okay, I feel you. I sense that dilemma. And actually, many of my students also, given what's happening in the country, parang, ma'am, what are we going to do? They want to do something. They sometimes feel helpless. They feel frustrated when their elders just tell them, keep your head down, just study, just act later on when you're a lawyer. No, they want to act now. There's that thing. Also, the same question, does it still make sense to be ethical when our elders are not ethical? Or when it pays to not be ethical? And perhaps my way of answering you would be to refer you to the letter of Ka Pepe Jokno, which he wrote to his son, and many lawyers might be familiar with that. He wrote a letter to his son when he was in jail. As you know, during martial law, he was imprisoned by the Marcos regime. And his son wanted to go to law school. And he was asking for advice as to whether he should go to law school. And Ka Pepe Jokno started the letter with a question posed by one of the soldiers, I think, or one of the jail guards. The jail guard asked the same thing. Does it make sense to be a lawyer now when it seems that the law does not matter, when the law is being broken? And I think you should read the letter for yourself. But what I want to mention to all of you here is what Ka Pepe said about, this time will pass. This is not forever. The period of martial law, it's not going to last forever. There will be a time when you will need to rebuild the institutions that have been razed to the ground. There'll be a time when you will have to rebuild your ethical moorings, your ethical foundation, the rule of law. And for that time, which is inevitable, we don't know when, but it's going to be inevitable, it's just a matter of time, we will need ethical lawyers, we will need strong lawyers to build the foundations. So don't lose the idealism. There are many, many good lawyers around you. Find the lawyers you admire, the professors you admire. Find the law students, the classmates who share the same ideals. Strengthen each other. There is strength in numbers, and there are many of us. We just need to find each other.
I think Tanya, there are two other questions. Can the systems be applied to other fields of law, and will ethics help in the bar?
Yes.
Very quickly.
Yes.
A yes for both. Okay. And I thought Deed Sentry was going to take the... that was a fake news. 1, 2... Yes, sir, please. And then, ma'am. And then, was there another hand here? Okay. Okay. I was looking forward to that question.
Good morning. I'm Judge Frank Lubrigo. We heard a practitioner, now hear a judge. There are instances that we hear from lawyers and non-lawyers say legal ethics is an oxymoron. After reading the title of that book, I am inclined to believe it. But the reality is corruption in the legal profession and in the judiciary is perceptual. We are fortunate from our ranks that the Supreme Court, through the PhilJA, is relentless in advocating for judicial integrity and independence with a longtime partner, the Konrad Adenauer Foundation. Just last week, we had a roundtable discussion, and I was invited. In the Philippines, there is a pervasive perception that the legal profession is corrupt as much as the judiciary. The good news is we are not alone. According to the Konrad Adenauer Foundation, the global perception is that judiciary ranks second to the police. The consolation is the International Bar Association of America, Judicial Integrity and Independence Initiative, reported that the perception of corruption is not the reality. Okay. It's always the proverbial basket of an apple. How many apples should be rotten to make the basket rotten? In our case, I would venture to say that there is no institutional corruption in the judiciary. But corruption in the judiciary as a perceptual thing is shared by the legal profession. After all, there won't be no judges without practitioner. There will be no corrupt judge without a corrupting practitioner. So they cannot be far behind.
Can you wrap up with your...
Yeah, I'm just putting
Yes, sir.
context to my
Okay,
question.
Thank you, sir.
I would like to ask Professor Lat, if in teaching potential lawyers, it is ever inputted that while we teach you norms, ethical norms, when you go out there, you will be facing this perception. It is not enough for a lawyer to be ethical by himself, but he should also address this perceptual corruption. Actually, I am retiring next year because I am fed up by this perceptual corruption. Sometimes bruited about by the practitioners themselves. Thank you.
Thank you. Yes, ma'am. So how to address the perceptual corruption?
Good morning. I am Rochelle Manuel, presiding judge of MTCC Mabalacat City and acting presiding judge of Angeles City branches 1 and 2. My question is addressed to Professor Lat. You mentioned that law students observe in court proceedings and even and they have, of course, obtained perceptions on courts. I think my question is, was there any program that on Court Watch? Because it would be a good program because it will encourage, of course, public accountability, transparency on the part of the court, not only on the part of the judges, but members of the officers of the court, the PAO, the prosecutors, for instance. Is there an existing or any initiatives to pursue such kind of program? Thank you.
Thank you, Judge. Any other interventions? If not, I would actually invite our 3 panelists to address the perceptual corruption in the judiciary. Maybe Peter could also share if such perception also applies in both Australia and New Zealand, and the point of how the PhilJA is also addressing this through training. And then any programs on Court Watch that you may also know of in Australia and New Zealand, and probably the thoughts of Justice Ascuna as well on monitoring the courts. Of course, Tanya has been the target of both interventions. Okay. Panelists, please.
I'll start with the second question about Court Watch. What we do, it's basically very informal. A number of colleagues of mine, so we teach a subject called legal profession, and some of the other subjects also require their students to go to court, but it's very informal. As far as I know, not all of the professors have adopted it, but for those who have, it's been very helpful. We ask them to go to court on their own. They make their own letters, they make their own arrangements, and so they come face to face directly with the bureaucracy. They talk to the clerks of court, they observe court proceedings. And the judges usually, when they find out that there are students in the audience, they will invite them over into chambers after, talk to them, which is an added bonus for them. So they have the benefit of observing firsthand and having mentoring afterwards. I think that would be very interesting if there was a court watch of sorts where it's an institutionalized practice. Maybe it's something that can be considered. I can mention this to the Legal Education Board and to the Philippine Association of Law Schools. Maybe the deans might be interested in this. And then just with regard to the perception of corruption, what I tell my students is that I think there is something about the imposition of Western culture on our indigenous gift-giving culture that has created this culture of corruption. It's so ingrained in Filipinos to give gifts. Diba, when we have visitors, we naturally give tokens, we invite people to eat. We think nothing of it. And so it's always goodwill when we offer food, we offer little tokens. But if you look at the Western studies, there are studies which show that small gifts actually can be very corrupting. They're actually even more corrupting than the big gifts, because the big gifts, you can turn them down right away. And so a discussion of corruption necessarily includes a discussion of Philippine culture. Why do we have this particular culture? And then how come the rules are not exactly aligned with our culture? So diba, there's still PD 46 which prohibits any kind of gift giving. Diba? You can be criminally sanctioned for gift giving of any sort, but that's at odds with our culture. So that's something that we talk about in class. Of course, different professors have different approaches, but this is something that we're trying to mainstream, discussing culture, discussing the problem of corruption within our psyche as a Filipino nation. So hopefully that helps address certain things. And we also tell people, if you are competent, if you are prepared for your cases, you don't have to bribe the judge. Diba? Sometimes corruption is a product of laziness. You didn't do your work, or you feel you have a losing case, or you don't want to try hard enough. If you are very good, if you come prepared, there's no reason why you will lose the case, or at least you will lose with dignity. So we tell our students, you have to prepare very well. And there are many cases where people get disbarred or they get suspended because of poor preparation for their cases. So that's something that can help address corruption.
Peter? Yeah.
In terms of New Zealand and Australia, well, I only feel able to comment on New Zealand, my home country, and compare it favourably to our neighbours across the Tasman Sea. But New Zealand and Denmark always are number one in the international transparency indexes for lack of corruption. Doesn't mean it doesn't exist, of course. It's just it's a perception thing. But and I always put it down to the fact that Denmark and New Zealand are both very small countries, and it's very hard to be corrupt in a very small society where everyone knows what everyone is doing. But our neighbours across the Tasman Sea, I wouldn't rank them very highly for the corruption stakes in terms of there's been a lot of scandals there over the years. But in terms of, I think Australia, to be fair to them, they're pretty high up in the corruption-free stakes. But in terms of how the whole ethics issue is addressed in legal education and with lawyers in New Zealand, I mean, you have to do an ethics course to get admitted to the bar. That's mandatory in New Zealand. You have to, foreign lawyers come in and have to do that mandatory ethics course as well. And one of the problems we do find with lawyers falling off the rails are foreign lawyers who've come in and got admitted in New Zealand and haven't taken notice of the ethics and professional responsibility. But also professional responsibility is ingrained in all the postgraduate pre-admission training courses as well. And so and the rules around, that's where most lawyers run into problems, is breaking the rules of professional conduct as opposed to legal ethics issues and that. So, but I think that there is a lot of focus and energy and effort put into legal ethics and professional conduct responsibility right throughout the whole system in both Australia and New Zealand.
Justice, would you also like to share, sir?
Yes. Our head of the Judicial Ethics Committee, Justice Hilarion Aquino, in a speech 2 years ago, said two problems of Philippine judiciary: court delay and corruption. And they are connected. I think the perception, it was in our forum mentioned by Judge Frank Labrigo, the perception why the judiciary is considered second only to the police in corruption worldwide is because of court delay. The litigants think that the delay in their cases is due to corruption. That is the finding. Therefore, if you want to solve this wrong perception, we have to solve the court delay. If you read decisions, even of our Supreme Court, in the statement of facts, this refers to an incident that happened in the year 2000, 2010, 10 years ago, 17 years ago. That's the time it's finally decided by the highest court. And the reason for this is because we are fond of litigation. Even a sack of rice has to go all the way up to the Supreme Court. So one solution is to fund the courts. We get only 1%, less than 1% of the national budget for the entire judiciary not the Supreme Court. The entire judiciary of Philippines gets less than 1% of the entire national budget. Imagine that. So what does the Supreme Court do? It maintains a 25% vacancy rate in the courts. Why? Because if the court is vacant, that is savings. And they use the savings to supplement the operations of the rest, the 75% of the courts that exist. So one solution is to convince Congress to give at least 2%, because with 2%, it is doable. The other is to be transparent. Of course, they have so many mantras. The Constitution itself says that public office is a public trust, and all public officials must dedicate themselves to their work and must lead modest lives. You have the Bible that says, do justice and live in the presence of your God. You have Shakespeare who said, to thine own self be true, and it must follow as the night the day, thou canst not then be false to any man. So you have all these mantras that you can follow. But in Africa, they have one thing. They call Court Users Committee. They form a Court Users Committee composed of community members, litigants, lawyers even, prosecutors, that will interact with the courts so that the court will know how they are perceived by the community. So these are mechanisms by which this wrong perception, Frank is right, this is not an accurate perception, but the perception is there. And you know, in psychology, perception is reality. So that is, we have to correct that perception because it acts like it's real. So I think there's a lot of work to be done, but we have to attack the court delay. And it's being attacked. We are now shifting to continuous trial in the Philippines, and PhilJA is training our judges with a lot of painful feedbacks on continuous trial, because that is the only way where an undermanned judiciary can cope with 8,000. We have 8,000 pending cases, 8 million pending cases in the trial courts. No, 800,000. It used to be 800,000 5 years ago. Now, only 600,000, largely through mediation. Mediation has helped declug. So it's now 650,000 all told. Supreme Court, about 12,000. So there is a need to adopt measures to speed up decision of cases, because that is the number one cause for the wrong perception that the judiciary is corrupt. Thank you.
Thank you, Justice. Before we go to the next round, I just would like to share with the good judge. I'll exercise my moderator's prerogative. I'll just share that there's also a civil society initiative in order to monitor the courts. And this was being done in coordination with the Supreme Court, but we all know what's happening with the Supreme Court, which is distracting the Supreme Court. But this initiative is called Justicia Natin. The Human Rights Center of Ateneo de Manila University is part of this consortium group, which is funded by the European Union, and together with some civil society organizations, such as the Philippine Alliance of Human Rights Advocates, and even the journalists and alternative law groups. So one thing that added up to that problem is the hesitation of the Supreme Court is that it might add to that perception of corruption and the problems in the judiciary. So communications is actually one thing that has to be addressed on how do these reforms actually add up to speeding up the processes in the court and addressing corruption. So I can talk to you and Tanya more about it, especially since she mentioned LEB and the Philippine Association of Law Schools. So we have 8 more minutes, and I saw 2 hands. Yes, sir. And Professor Leo afterwards.
Good morning. Thank you, Mr. Preet, Professor Lat, and Justice Ascuna. This is not a question, this is a reaction. I'm Tony Ligon, I'm a practitioner and trying hard to be a professor. uh, Regarding the perception on the judiciary and the law practitioner, I will admonish my friend here, the good judge, not to leave. The more that you should stay, because we are living in interesting times. And I am inspired by Professor Lat's teaching on ethics, and I am reminded of my first year law professor, the late Pompeo Diaz, on what he said. He had this speech, passion for justice. The Greeks have this prasus, you know, and I think we should tell our students or our colleagues to be reminded that in order to serve law, we must maintain this passion for truth and passion for justice. Let me just quote what Justice Pompeo said, and this is a very short one, but this is a long one actually, but I just quoted the favorite line I wanted to share with you. What a man of law should possess is a passion for the truth, a passion for justice. This passion should be of such magnitude as to give him the power to stand firm what those around him seem to be going mad. It should be of such solidity as to grant him the strength to stand alone when all else is turning into dust. It should be of such perseverance as to infuse him with loneliness that only those who have a vision can endure. It is a passion to keep alive that eternal challenge that justice must be done, whatever be the cost. I think I will remind Judge Lubrigo not to leave the judiciary just because of that. Thank you.
Thank you, sir. Prof. Leo, and then one more over there. I'm delighted to see Prof. Leo Batad from the University of the Philippines College of Law. So, Prof. Leo, I already introduced you.
Yes, thank you very much. During my time when first of all, I would like to congratulate all of the speakers, and listening to Professor Tanya Lat, I'm very proud because she was my student in legal ethics. At the time when I was still teaching legal ethics, but since then I moved on to labor law and criminal procedure. But anyway, when I took the bar, and I think it's still the same, it's the same rule, that legal ethics as one of the 8 courses is only 5%, okay? So I feel that that's the way we give importance to legal ethics. And it was not even legal ethics question, because there were also legal forms, no? So it's not only legal ethics, but that's 5%. Now recently there are suggestions that we remove legal ethics as one of the subjects in the bar exam. And of course, some of the proposals would be that it should just be distributed in the other 7 subjects of the bar. So I would just like to know from the 3 resource persons, from Justice Ascuna, Professor Lat, and of course, Professor Treat, what are your thoughts about this?
Thank you, Prof. Leo. There was one more hand there at the back over there. Yes.
Good morning. I'm State Solicitor Gilbert Medrano, also from the Ateneo and from San Beda. My question or concern does not pertain directly to corruption or ethics, but I guess somehow it will be related in a way. It's about the use of technology, which was impressively lectured on by Professor Peter. I was just wondering, sir, in the Philippines, I'm not exactly sure how it is done elsewhere, but in the Philippines, there is one specific profession where the top-notchers actually have their photos published at the front page of the papers every time the results come out. And in the Philippines, it's the Philippine Bar or the lawyers' results. There is no other profession in the Philippines where the top-notcher in the medical board, engineering board, or architectural board get their photos printed in the same way. So there is this different high perception about lawyers in the Philippines. I just wonder, how different is the perception of lawyers in Australasia, And then contextually, with the increasing use of technology in teaching law students, is there any significant or marked difference in the quality of lawyers in your territory, sir, as regards their bar rating, performance? My concern really boils down to the so-called millennial generation, where the kids of today, including law students, would actually prefer to communicate through a gadget rather than to socially and physically interact. But I grew up in the so-called Socratic generation, and I would like to think that that generation perhaps was taught law in a better manner than our kids are being taught now. But of course, that's a matter of perception again. Your thoughts, sir, please. Thank you.
Thank you. Yes, I'll just tell our speakers that you have 2 minutes each to wrap up as well. Thank you. Go ahead, Peter.
In terms of the perceptions of the legal profession in Australia and New Zealand, I think generally people think there are far too many of them, and they don't have a very good opinion of them. But having said that, and they're not ranked very highly in terms of public perceptions of people that are admired, but people who are a lot lower are politicians and journalists, and so I mean it's the ranking is a very difficult thing. I mean, a career in law has traditionally been one that's around there for people who want a professional career in some particular area. I mean, when I grew up, I mean, my mum and dad didn't go to university, and I was the first. And I looked around, what shall I do? Well, I chose law because that looks like something that'll get me a good job. Not because I had any burning ambition to be a lawyer, but so I chose that as my thing. But I think people still do that, but it's still overwhelmingly dominated by people whose parents are also lawyers, who go on to become in the legal profession, like a passing on. And the most interesting thing about the New Zealand legal profession now is that 67% of all graduates and new entries are women, and in fact 2 years ago 50% of the profession became female. So it's becoming what's known as a female profession, and that has implications in its own, because that's happened to teaching, it's happened to a lot of other professions, and that has a lot of implications for the future as well. So I think, and there was another question I've forgotten. Yes, the ethics in the, because we actually tried an experiment in our professional legal studies course, a mandatory pre-training course, where we integrated the ethics and professional responsibility into all the other modules. And what we found is that the students, when they came to do the assessments and that, didn't do very well at all, because they need to focus on something in a particular area. And so we only used that for 1 year, that experiment, and decided it wasn't worth doing. So we went back to having a discrete course on professional responsibility and ethics.
Thank you, Peter. Tanya?
I agree with Professor Chit. I've heard of those proposals, and thank you, Professor Batad, for teaching me ethics. That laid the foundation for what I'm doing now. I disagree with the proposals to get rid of ethics as a separate subject, because for the same reason as what Professor Chit said, it's going to be downplayed and perhaps eventually done away with. The substantive courses will always trump the lighter, quote-unquote, courses. So ethics should be retained as a separate subject. And I would like to adopt the proposal, which is being done in other countries. Some states in the United States, I think, if you don't pass the ethics exam, even if you do very well in the substantive exam, you don't get admitted. That's the only way to make our ethics exam something that they will take seriously. It has to be, it really has to bar entry to those who don't deserve to pass.
Justice?
I think the method of teaching, when we surveyed the judges who are the ones who are teaching or training, they prefer a combination of on-site and online training. They don't want to give up face-to-face. Still, they want face-to-face, but they are amenable to getting online courses as well. On the millennials, you have to adapt to them. that is the way they learn, through interaction with media. That's their tool. That's the way through to their brain. So I think with the millennials, you have to have a different approach. So basically, I think we are faced with the choice between giving up face-to-face teaching. Maybe in the future, we don't have to do that. We just implant the learning in the brain. And when you wake up, you already know everything, constitutional law. That is very near already, that type of future. But until then, we have to have the basic, I think, traditional Socratic method is still the best for me. Thank you.
Okay, with that, we will end our session this morning. Please join me in thanking all of you, and especially our speakers, for a very interactive session. We will have a book launch in 10 minutes. So in the meantime, I would invite you for the gift of food, not to corrupt you, okay, as was mentioned earlier, but to nourish your stomachs. May I invite you to please come back here after 10 minutes. After 10 minutes. Thank you. Good morning. I'd like to invite everyone to please come back inside. We'll start the program in a few minutes.
Grabe talaga si Mahal.
May invite everyone to please settle down. We'll start in 1 minute. We'll start in 1 minute. And paging Miss Blythe Lumage. Before we go to our book launch proper, we will be giving some updates regarding the proceedings of the last Congress that we had. Okay? So may I invite everyone to please settle down. We'll be starting. Okay, may I get your attention, please, everyone? Please settle down. Okay, please find your places again. Okay, to give us some updates. Okay, we'll start now. We'll start. Excuse me, everyone. Can I get your attention, please? Excuse me. Okay, thank you very much for your kind attention. Before we proceed with the book launch, we will hear some updates regarding the proceedings of the last conference. May I invite Dr. Angel Rodriguez of the University of Malaga, Faculty of Law, and Dean Gemma Tomas of Deusto University, Faculty of Law, to give us the updates. Please.
Good morning to all of you. This is going to be a very brief announcement. As you may remember, the third Congress of this series was held at the University of Malaga, Spain, last year in May 2017. And we are very proud to announce that the proceedings of that Congress have been published by the prestigious legal law journal Estudios de Deusto in Spain. So now Professor Gemma Torres, the Dean of the Deusto Law Faculty, will introduce you the journal. Please, Dean.
Thank you, Professor Rodriguez. Just a few notes about the Estudios de Deusto Law Journal. It's a scientific journal founded in 1904. Actually, it's the oldest journal in Deusto we have. This journal publishes articles that are the result of original research in the different areas of the law. It publishes currently 2 issues a year and follows the so-called double-blind evaluation system, and is included, among others, in the following indexes and databases like ESOC, DIALNet, Latindex, MIAR. Well, I'm not going to say all of them, Carus, CIRC, and so on. Estudios de Deusto also publishes special issues devoted to legal issues that present implications from different sectors of the law. Topics analyzing special issues have been, for instance, constitution and globalization, the economic crisis and its impact within the constitutional legal order, freedom of expression, decentralization and competition law, constitutional markets within the crisis of the European Union, globalization and the welfare state, current constitutional debates in Europe and Asia. Estudios de Deusto welcomes particularly manuscripts from law professors affiliated with international universities. And well, in our website, or looking for in internet, you can find information about the journal, and you are very welcome if you want to send your manuscripts to the journal in the future. Of course, you are very welcome. Thank you.
Thank you. I would now to very briefly review with you the content of the volume. The topic of the Third Scientific Congress on Private Law of the Philippines and Spain was globalization and the welfare state, current constitutional debates in Europe and Asia. Father President Villarin pointed out on Tuesday that we lawyers used to use the term scientific in a very broad way. Now you can realize that we have also a very broad idea of private law. Anyway, that was the topic of the Congress, and 8 papers presented to the Congress have been published in this volume, both from the Philippine and the Spanish side. The volume is opened with an excellent study by Professor Ruben Balane on the Spanish roots of Philippine law. Then we have contributions by Professor Setfrey Candelaria, Professor Tanya Lat, Professor Maita Chang Gonzaga, and also Professor Alvin Yak on welfare state and the ocean. And then from the Spanish side, contributions from leading Spanish scholars of Professor Miguel Revenga, comparing the Constitution of Cádiz and the Constitution of Malolos. Contributions by Professor Miguel Agudo from the University of Córdoba, Professor Rafael Rubio from Universidad Complutense de Madrid, and other leading Spanish scholars as well. And then finally, I must add that we had the pleasure to receive more than 50 communications to the panels. A selection of them have been also published in this volume. Jean Monnet, one of the founding fathers of the European Union, said once that nothing starts without individuals, but nothing remains without institutions. From the Academy, we could add that nothing survives without a publication. Now we have the publication of those proceedings. I'm very proud to announce that to you today. Thank you.
Thank you, Dr. Rodriguez and Dean Martinez. Okay, so there's one more presentation. Okay. I now invite Professor Jose Manuel de Torres Perea.
Dear friends, we are honored to introduce a new web page. We have launched between 3 universities: University of Malaga, Ateneo de Manila, and University of the Philippines. That is a result of Erasmus Plus K107 project. And after all these successful conventions, we thought it was the moment to start working together in a continuous way. So this is the place we have think about in order to be together working, both faculty members, attorneys from Spain and from Philippines. The problem, to be honest, is the speed of internet here. Then if I try to open everything, I think this is finished. So the only possibility I have is to explain what is inside, and the only possibility you have is to believe in me. That is a double possibility. Well, here is, of course, the welcome. there is a white
Sunny.
space waiting for you. Feel free. The most important Spanish regulations in English is there. Of course, in the Filipinos ones as well. We have comment of Spanish Civil Code. We have here all the comment of Manresa are in this page. You can open and see it. And we have, for example, the Fisher Civil Code. The Fisher version in English of Spanish Civil Code is here in this web page as well. If you go to case law, we have contact with the most important web page of Filipino web page in case law, and the most important Spanish web page about Supreme Court case law. Not all in the Spanish side, half of them are in English, half of them are in Spanish. But okay, it's there. About legal research, that is information about reviews that we have in Spain, but that are published in English. We have different, from INDRED to medical health, to another one in business, are all online, open online reviews that are all in English, but also we include reviews from Puerto Rico and from Mexico, because it's all our cultural area. And finally, between universities is the connection, is a relation of what has been our activity in the former year, where we are here, what we have been preparing, and there is a very important link. It's a link with Spanish professionals, academic members of different expertise areas, where you can contact with them. If you want about a civil law problem, to contact directly with a Spanish professor of a commercial law or a criminal law, we allow you the way to find him. Then I think that is the real way to start working together. And here is, on the right side, the highlight menu, legal news in Spain. Well, we are going to introduce here legal news that we consider interested. I hope that on the side of UP and Ateneo, you participate in this web page and you introduce the legal news that are, we suggest to link that this is a UMA, University of Malaga web page. We suggest to link to the Ateneo and to UP. Then there is legal advice about Spanish law. That is a lot of links from the possibility to work as an attorney in Spain and how is the system there. And when there is link of interest, well, we have introduced some links about the city of Malaga because we love our city. And even to find accommodation in Malaga is there the possibility. Okay, I think that is our contribution in order that this, that is a project for a week, will be not only a project of a week, that from now will be a continuous relationship to work really together. Salamat.
Thank you very much to all our academic partners in showing everyone the continuity of the Philippine-Spain partnership with regard to legal education and legal practice. Now we will now proceed to the book launching of Obligations and Contracts, authored by Professor Ruben F. Balane. May I now invite Dean Jose Maria G. Hofilenia, Dean of the Ateneo Law School, to give his opening and congratulatory remarks.
A very pleasant good morning to everyone, and thank you for coming. On behalf of the Ateneo Law School, I am delighted to welcome you to this very special event, the launching of the newest book in town on obligations and contracts, entitled Jottings and Jurisprudence in Civil Law, Obligations and Contracts. We are indeed very fortunate that we have within our clutches a new law textbook that will most certainly enrich our and our students' study and appreciation of this essential portion of the Philippine Civil Code. I am eager to read it myself and look at its contents and refresh my knowledge on the law, relevant and recent jurisprudence, and bask in its insightful analysis. And because the author of this book that we launched today is the foremost erudite and acknowledged authority on civil law in the Philippines, the Professor Ruben Balane, I am all but certain that his immeasurable wisdom will be jumping out of each and every page of this volume. But over and beyond this book serving as an embodiment of and a testament to his preeminent intelligence, this book simultaneously betrays Professor Balane's unwavering devotion to the law as an academic and a professional, and his deep generosity as a human being. Writing a textbook like this one requires a not insignificant amount of time. Time that Professor Balane could have otherwise spent on more idle and comfortable pursuits. Writing a textbook like this one requires painstaking efforts. An exertion of effort that Professor Balane could have easily avoided by succumbing to a most understandable desire not to bring more stress to himself. Writing a textbook like this one necessarily requires big-heartedness. That Professor Balane possesses a heart much bigger than his body can contain is a matter of which we need no convincing. But nonetheless, through this book, we see that rather than keep his invaluable thoughts, writings, and reflections to himself, Professor Balane innately yearns to guide us through the law on obligations and contracts, and through it to educate his students on this law in the best possible manner in order for each one of them to better achieve their most cherished dreams. To be sure, by his conscientious writing of this book and sharing it with us, the author not only gives us an annotation on obligations and contracts, he regales us with his very self, his very selfless soul. And because that author is our Professor Ruben Balane, what an amazingly beautiful self and soul that is. Much congratulations, Professor Ruben Balane. We are overjoyed that you have entrusted to us a valuable part of yourself through your book. And in a brazen expression of self-regard, let me say that I am close to delirious that you have chosen to launch your book here at the Ateneo de Manila University School of Law. Congratulations again. Thank you, and good morning to each one.
Thank you very much, Dean Joey, for that very fitting congratulatory message to Professor Balane. May I also invite Professor Jose Manuel de Torres Perea to give his thoughts on both the author and his work.
Thank you very much. Professor Balane asked me to write the preface of the book, but he asked me something very strange. Please, not to use English. I want you to write in Spanish. So sorry. What I am going to do is to translate in English what you can read in Spanish. That is, then is the preface, el prólogo or preface. This history begins 800 years ago, when the University of Salamanca in Spain was founded. This university soon became one of the pillars of the first process of globalization in our earth. In their classrooms were trained scholars and professors that from 1538, that is the year when was founded the University of Santo Tomás de Aquino in the República Dominicana, they will arrive in the different Latin American universities. And from 1734 to the University of Santo Tomás in Manila. These academic ambassadors brought to the Philippines not only the religion, but also a Greco-Latin culture tradition from more of 2,000 years old. A Greco-Latin tradition that had shaped the identity and the spirit of the Filipino people from them. It can safely be said that Professor Ruben Balane Figueroa is now the greatest exponent of this millennial tradition in the Philippines. Ruben Balane is a creative genius, typical from the Renaissance, wise in different disciplines, profound knower of several languages, master, reference, mentor, and teacher of several generations of jurists, and above all, profoundly humble, pleasant, and just. Certainly, he is a model for every single decent human being, and especially a model for every university professor, a dream to reach for stars. In fact, the three qualities of the Tria Juris Precepti, the three qualities to reach happiness, are converging in him. Like Roman said, honeste vivere, alterum non ledere, et sium quici tribuere. Moreover, Professor Ruben Balane is generous without limits. He has determined doing his whole life to put his wisdom and knowledge at the service of others. Anyone who has closely been close to him learns not only law, but humanity, temperance. Ruben Balane is a lighthouse that guides, a bonfire with mud made the place feel warm and lively, that give us hope, a lighthouse, a bonfire that should never fade. For all that, it is an honor for me to have the privilege of being able to preface this work. Indeed, this is an historic moment. Now that the great jurists are asking, quo vadis ius civile, precisely this book on obligation and contracts offers the freshness and new inspiration that we need. A reference that remains loyal to the Philippine civil tradition. A tradition that on the basis of the Spanish Civil Code, meaning the partidas of the wise king and the Civil Code of Napoleon, has kept the flame of the purest Greco-Latin cultural heritage on these beautiful islands of the Pacific Ocean. I cannot close without mentioning the risk that implies to renounce our roots. Law is a way to understand the life of a community, Hence, please, Filipino brothers, take care of Professor Balane, that the fire that this legal tradition that he embodies will never extinguish. Salamat, kapadit, na lalaki Ruben.
Thank you very much, Professor Peping, for that very personal message and for translating the Spanish preface in the book. Now we would not retype it and depend on Google Translate anymore. Okay. May I now call on Dean Sedfrey Candelaria to give his message.
Dearly beloved friends, my brief sharing today will depart a bit from the preface that I have written. Since it is in English, you can read it. And I'm sure you would like to read it also with the entire book. That's the message. Read the entire book. My sharing will be a little more personal. Professor Balane started teaching at the Ateneo in the early 80s. I was then in third year when I had him for succession. His reputation from the UP College of Law as a teacher scared us to death. We had horrible stories. But as the semester in succession unfolded, my batchmates and I, the guinea pig in his class, began to wonder, well, what is there to be scared about anyway? When he started commenting on the provisions of the new civil code and providing the historical background on our civil law tradition, we began to appreciate the richness of our legal system. My first semester on succession, however, would not end without an uneventful experience. His much dreaded canned provisions on the legitim, and at that time we had 4 categories of illegitimate children to memorize. And at any time you can be called within the semester. You don't know what time of the semester you'll be called, but you have to memorize it. Day in and day out, in the toilet, everywhere you go, because you have to be prepared to blurt out the combinations. The midterms and the horrible finals. Well, as fate would have it, I survived with only His mercy. A number of my batchmates and I would move on with him in 4th year, the whole of civil law review. Ngayon lang namin naintindihan ng civil law. Further, we were treated to an amazing walk through the different books of the code with all the literary flair, Greek mythology, Roman law, Spanish history, the life of Jose Rizal, and whatever breathes life into the provisions of the law. A truly Renaissance academic. I thank you, Prof. Ruben, for your commitment to legal scholarship, not just here, but globally. Of course, of immediate importance today, however, is the book of Professor Ruben F. Balane on obligations and contracts. I really do not know, Prof, how persuasive I have been in making you decide to embark on this project. I know you had your notes. You have been telling me about it. I can only surmise our occasional dinners with our common friend, Akong, where I think opportunities were given for me to politely suggest every now and then, kahit pare-pareho pinag-uusapan natin dyan, to see your imagined book to its logical conclusion. I know you would often complain about your eyes, about your failing health at times, but I prayed very hard the last few years, and especially when I came on board as Dean of the law school more than 6 years ago, that I would like to see a product of this Renaissance academic done before my term ends. Prof, I saw you each day the last few months painstakingly work on the manuscript of the book. I know that this 4th Congress truly inspired you to finish the book, and I can say today that you have just given both academics from Spain and the Philippines an enduring legacy, a book now to be read by millennial practitioners and judges in both jurisdictions. Maraming salamat, Professor Ruben F. Balane.
Thank you very much, Dean Cedfri Candelaria, for that very personal and touching story, touching tribute. Sorry, because the horrible story stuck with me. Because I assure Professor Ruben that Dean Cedfri passed on or carried on the horrible story reputation, as he was my professor as well in constitutional law. Okay. We now proceed with the next message coming from the Chancellor of the Philippine Judicial Academy, Justice Adolfo Ascuna, sir.
Professor Ruben F. Balane, the man, not the book, is the chair of PhilJA's Civil Law Department in our academic council. It was asked, why is it that Philippines publishes the top-notchers in the bar, but not the top-notchers in medicine or engineering, whereas other countries have other glamorous professions? For instance, in Thailand, I asked them, what's the most glamorous? What do you want to be when you are young? Military, not lawyers. The military is the prestigious profession in Thailand. In Japan, what is the most privileged and respected profession? Not lawyers, teachers, sensei. When you mention sensei, everybody bows. Teacher. Well, Ruben Balane is not military, but he is both a teacher and a lawyer. And this book demonstrates that. He asked me if I could write a preface to his book. I said, okay, give me your book. It took him a long time to give me the book, as he had painstakingly had to write and rewrite it. You know, he is an expert on succession. His first book is on succession. And within succession, he is an expert on reservas. Reserva troncal, for instance. In this room, he is the only one who knows about reserva troncal. You know why even our Spanish colleagues don't know reserva troncal? Because they have abolished all reservas. When he found out that Spain already abolished reservas, that was his claim to fame, his expertise as reservas. He decided to write another book. That is why he wrote Obligations and Contracts. But we have to take this book in the context of the subject, obligations and contracts. For a long time, the Bible on Obligations and Contract was a book written by Puno and J.B.L. Reyes. This was the Bible. But it's old already. There was a need for a new book. That's why I asked our colleagues from Spain. Castan already dead. Who is your present Castan? Is there? Oh, yes. I asked Carmen, this Carmen Diaz, criminal law expert. I asked her, what do you teach? ¿Qué enseña usted en la universidad? They said, Derecho Penal. Then I asked, who is the living, not dead, author today in Spain on Derecho Penal? She readily gave me the name, Francisco Muñoz Conde. Did he write a book? Oh yes, plenty. And his book is very easy to read. That's why she prescribes it to their students. Then I thought of Professor Balane's book. When I wrote the preface, I said it is scholarly and fun to read. It really is fun to read. It's very well written. First, he gives you the concept, and then he gives you examples and cases, and then analysis. Article by article. Imagine that. He does this through all the articles. And he starts the book in Latin and ends it in Latin also. That is the lingua franca of the civilized world. There is a story going around the internet now that in 1587, King Philip II of Spain, Felipe II, the one after whom the Philippines is named, okay, was presiding over the most powerful state in the world at that time. Spain was the most powerful state. And they had a new colony in the Philippines. And those who came from Spain to the Philippines were bitten by mosquitoes and wanted to go back to Spain. So King Philip wanted to close the colonies. It was a Jesuit priest who convinced him not to close the colonies. Father Alonso Sanchez, S.J., together with a 10-year-old boy from Pampanga, Martin Sancho, went to Spain. Took them 15 months to reach the court of Philip II, and they were given an audience. And what's the purpose? To show that this young boy from the Philippines is a demonstration of why Spain should continue the colonies. The boy could recite the entire catechism in Latin, and that convinced Philip II that there is a future in the Philippines, that the natives can be taught, they can be taught the Doctrina Christiana. And that was why Spain stayed. Instead of leaving the Philippines in 1588, they stayed up to 1898. That's why we have the Civil Code. Código Civil. 300 years under Spain and 50 years under the U.S. 300 years in the convent, 50 years in Hollywood. That is our distinct culture. When the Philippines presented to Spain a copy of our civil code, presented by our Dean Bukobo, head of the Civil Code Commission that drafted it, it was presented to the Justice Jose Castan, who wrote, of course, the Bible on civil law, along with Manresa. And Justice Castan asked Professor Bukobo only one question. How long did you take to prepare your civil code? And Dean Bukobo probably said, 9 months. So Castan said, I admire the courage of the Filipinos. It took them years and years to prepare their civil code. You know, Philippines, in 9 months, we finished ours. That's why Professor Balani took long to write his obligations and contracts. Finally, he gave me the galley. I said, just the galley. I just want to see whether there's really such a book. So Finally, he gave me the galley proof, and I wrote my preface, and I was very happy to see that my good friend has come up with a magnum opus worthy to replace J.B.L. Reyes and Professor Puno's magnum opus years ago. So, without further ado, let us hear from him and let us see the book. Thank you.
Thank you very much, Justice Azcuna, for that very lively and animated tribute to Professor Ruben Balane. And to borrow Dean Joey's words earlier, that we see here that when we see erudites walking around, we pertain to them as walking textbooks. So it's very good that we hear that Professor Balane has shared a part of himself in another book on obligations and contracts. And now to hear from the book, or I mean the man himself, just kidding, to listen to to hear the response of the man and not the book, the Professor Ruben F. Balane, sir.
Thank you very much. Please be seated. Good morning to all of you. Muy buenos días a todos. Magandang umaga po sa inyong lahat. Justice Adolf Azcuna, my boss at PhilJA. Dean Ced Candelaria, my boss at the Ateneo. Dean Deng Cordero, Tan. I somehow still think of you at Deng Cordero because that was your name when you were my student. My boss at UP, Dean Nilo Divina. Is he here? Yes. My boss at UST. These are the schools where I teach. I have very many bosses. Dean Joey Ofilenia, my incoming boss at the Ateneo. Dean Hinojosa Torralvo of the University of Malaga, one of our honored guests. Dean Gemma Tomas of the Law Faculty of the Justo in Bilbao, another honored guest of ours. My very good friend, Peping, whom I baptized as Peping when he came here the first time. The esteemed members of the delegation from Spain, both from Malaga and from the Justo, who have graced this very successful fourth conference, now this time multidisciplinary. Well, Attorney RP, I'm glad that you're no longer terrorized by me. My friend, former Vice President Jojo Binay, he was here earlier. I don't know if he's still here. Yes, my good friend from law school days and from after. We were schoolmates at UP. Fellow members of the faculty, fellow students of law, ladies and gentlemen. I think this has turned out to be a canonization ceremony. First of all, you will forgive me for a few minutes of rambling, disorganized remarks. Let me tell you that this book that we are launching today is really the result of duress. I haven't decided yet before I file suit whether the duress was violence, intimidation, or undue influence. One fine afternoon, I'm summoned by Dean Ced to his office. And he says, Prof, why don't you write a book on obligations and contracts? I don't know where he got that idea. It was something that I had thought of before, but I had scuttled because of deteriorating vision. So I was ready with excuse after excuse. I said, my eyes are very bad now, hindi ko na kaya yan. He says, I'll give you a legal researcher. He had an answer for everything. I said, and I have a very heavy teaching load. I'll give you a sabbatical. Take all the time you want. You know, Sedfrey is not the kind of fellow that you can ward off. So, so by sheer brainwashing, he was able to overrule all my demurrers. So I started to write the book. It took me, I started writing it in January of 2017. I had just recovered from a bout with pneumonia, which was near fatal. So it was my way of convalescing by writing this book. And I put the last dot on the last I and the last cross on the last T in December of 2017. And the law office, of which I am special counsel, I think one of the partners, I saw him earlier, Attorney Leo Laurente, brought out a bottle of Dom Perignon to celebrate the completion, at least, of the manuscript. It was literally a manuscript. I had it written longhand on yellow pad because I am antediluvian. I do not know how to work a computer. In TypeScript, it ran for 1,440 pages. Now I think it covers 808 or so pages. So this was the most difficult task I had to undertake. Pinagpawisan ako ng dugo dito. Because I remember what the late Justice Ed Kagiwa used to say, and I fully agreed with him. Obligations and contracts is the most difficult subject to learn. It is also the most difficult subject to teach, at least in civil law, and it is the most difficult subject to write about. It is very abstract. Succession is peanuts compared to obligations and contracts. And so here now we are observing that the result of that duress perpetrated by Dean Said on me. And so now that it's here, what can I do but express my heartfelt thanks to all who have had a hand in the coming into existence of this book. First, to Dean Said, it's really in a very real sense, he was the one who made this book come into existence. This is really his project. In a sense, I'm just an instrument of that determination of his to have this book on obligations and contracts. Then I'd like to express my really warm and heartfelt thanks to the three gentlemen who wrote prefaces. First, my boss and dear friend, Justice Adolf, whom I knew from way back. Justice Adolf is just a bit older than I. And so I can call him Kuya Adolf. And then, of course, the other two preface writers, Dean Said and Professor Piping Torres Perea, who are both young enough to be my sons, as indeed I regard them as my sons. So many others to thank. The Ateneo Law School, the UP College of Law, my research assistant par excellence, I think he's here, Attorney Dake Mandukdok. Attorney Dake, will you please stand up and be recognized? He did a yeoman's job of beating this deadline and succeeding, shepherding it through the press. So many others that had a hand in the whole long process of the writing of this book. The law office of Haromay Laurente Pamaos, who is hosting a lunch after this. I wrote much of the manuscript in their office in Quezon City. The law office of Subido Pahente Certeza Mendoza and Binay in Makati, where I was given the hospitality of the facilities of the library in the course of writing the book. So those are to many others whom I should thank, but whose names do not come to mind. Anyway, those names are written in the heart of the Lord. Just a few remarks about perhaps the milieu, the matrix, the context in which this book was written. Professor Peping, in his preface, which he translated into English, asks the question, Quo vadis ius civile? Maybe we should ask that question too, in little narrower context. Quo vadis ius civile Philippinense? Whither thou goest? Where are you headed for, Philippine civil law? But that question should be asked with another question. A quo venisti ius civile Philippinense? Where did you come from, Philippine civil law? I remember 2 days ago, Justice Joey, Justice Joey, that should be prophetic word. Dean Joey in his welcome remarks said that everything has to be contextualized in the present, the future, and the past. Well, we are in the present, and everything we do in the present is, of course, in anticipation of what will come in the future. But we cannot do anything significant in the present to anticipate the problems of the future if we do not have an idea of what the past was. So it's all a continuum, all a spectrum. And knowledge of the past is essential, otherwise we are doomed to doing something meaningless. There's a beautiful saying in Tagalog, ang hindi marunong lumingon sa pinanggalingan ay hindi makakarating sa tinutunguhan. He who does not look back to his origin is doomed never to reach his destination. We have to look back at our origins. In the Philippines, as we all know, and this is also something I'd like to share with our Spanish friends, at the turn of the 20th century, the late 19th and the early 20th, the educated Filipino was Spanish-speaking. And there was a blossoming of culture in the Philippines during those times. There was a change of sovereignty in that era. The Philippine intellectual spirit started to flower in that era, in full bloom. In the field of literature, we had the great Filipino romantic writers who wrote in the different genres of literature, drama, poetry, essay, novel. The names of course, Jose Rizal, the most prominent of all. You had Cecilio Apostol, you had Pepe Palma, who wrote our national anthem, the Tierra Dorada. You have Balmori, you have Bernabe, Claro M. Recto, both a playwright and a poet. There's a blooming of literary talent in that era. In the legal field, we had the great civil law scholars. Justice Adolf mentioned Jorge Bocobo, one of the great civilists. They were titans, true legitimate successors and contemporaries of the legendary Spanish civil law commentators. You had Cayetano Arellano, who in one of his decisions explained the view of Manresa on illegitimate children and openly disagreed with him. You had J.B.L. Reyes, who analyzed and demolished Chevola's theory of Reserva Integral. There was an embarrassment of riches, of talent, legal talent, in civil law. But in the meantime, something was happening. The light that was Philippine culture expressed in Spanish started to flicker until it went out. Eventually, the lines of communication went dead. We became as islanded in culture as we were islanded in geography. The event that triggered that, of course, was the language change, especially after the war. The language of communication became exclusively English. The educated Filipino lost Spanish. Spanish fell into disuse. The Spanish law books were consigned to limbo in the libraries. The young legal scholars, fresh from the law schools in the Philippines, hied off to North America, to the United States, and the preferred destinations for their graduate studies were Harvard, Yale, Michigan, NYU, Georgetown, great centers of learning. But where they imbibed common law principles, American law points of view. So we were cut off from our civil law roots. We were isolated, separated from our Spanish links. Our civil law withered on the vine. Worse, it was cut off from the vine. So these young scholars coming back from America started writing books. Many of them wrote books on civil law, because civil law is one of the big areas of study in the curriculum of all the law schools here. But they started writing books commenting on provisions of the Spanish Civil Code, which is law here until 1950, and then on the provisions of the Philippine Civil Code, which is really, to a certain extent, as my friend Piping accurately observes, an English translation of the Spanish Code. They started writing, these young scholars, writing books on civil law, started writing comments on these provisions of the Civil Code on the basis of American materials. And they saw the difficulty. But they could not do otherwise because they had no more access to the Spanish sources, because they knew no Spanish any longer. So how do you explain from American sources ideas and concepts like accesión discreta, caución juratoria, sustitución fideicomisaria, acción pauliana, and the great villain, reserva troncal? How do you explain these concepts, which we borrowed from Spanish law, in American law terms? That's like trying to explain the bullfight in the terminology of basketball. That was the absurd situation in which we were, and in a sense in which we still are. 4 years ago, something serendipitous happened. People in Spanish law and people in Philippine law, from Spain and from the Philippines, shook hands, got to know each other. And then they discovered, interestingly and very ironically, that they could now revive links and communicate with each other through a shared language, which is the English language, which was the language which caused us to be separated from them in the first place. Truly, Dios escribe derecho con líneas torcidas. God writes straight with crooked lines. So now we could communicate again in English. And that is what has been happening. And we saw that these past 3 days, these very exciting 3 days, where there's been a lot of intercommunication, a lot of thought sharing, not only in civil law, but in the other disciplines, between Spain and the Philippines. And now we see the possibility that perhaps our young scholars who will choose civil law as their field, perhaps now they can go back to the roots of our very beautiful, our magnificent civil law tradition. For indeed, we are legitimate heirs of the civil law tradition. That they can go back to Europe through Spain and further their studies in civil law. So now we do not have to clothe ourselves in American concepts for civil law, but go back to the real tradition. That is the hope that we now are allowed to entertain because of these links. First, it started very small on a person-to-person basis, and then we became Ateneo and UP and the University of Malaga, and now you have others coming in. Other law schools, we have now, for example, the Facultad de Derecho of the Justo in Bilbao, where we expect to go next year. And this book is puny, it is insignificant. It's a footnote to that development. We don't need this book for that development. If anything, it's just a small token. But this book is dedicated to that giant of Philippine civil law, Justice J.B.L. Reyes. It's an icon to all of us Filipino lawyers for his erudition, for his integrity, for the purity of his soul. And let me use the words of our national hero as I dedicate this book to him. Sírvanse estas páginas como una tardía corona de hojas secas sobre tu olvidada tumba. May these pages serve as a belated wreath of dried leaves on your forgotten tomb. Even that is symbolic as we dedicate to him, as I dedicate to him this book. It is symbolic now of this perceived, our perception, start of rekindling the flame that was snuffed out in the mid-20th century and going back to our roots and re-enriching the civil law tradition that we had in full measure. Now perhaps we can continue. We need the help, we need the support of our Spanish friends, because that is the country to turn to if we wish to revive our civil law tradition. I like to believe, and this is my last thought for this morning, I like to believe that in doing this, in my writing this book, holding this conference, we are burying a seed in the soil, hopeful that it will eventually sprout and grow and become a majestic tree with overarching branches and thick leaves. Like Claro Embrecto, who wrote in one of his books, we are planting, burying that seed, hoping for the tree to grow, knowing that we will never sit in its shade. When the tree is full grown, we won't be around anymore. Perhaps people will not even know our names. That doesn't matter. My friend of happy memory, Professor Heidi Orak, used to say, we do not have a passion to be remembered. But the important thing is not the one who buried the seed in the ground. The important thing is the tree. So that many, many years, maybe decades, many centuries later, when the tree is full grown, and it stands majestic, it will be a tree that is robustly alive because its roots, again, draw nourishment from the life-giving waters of the civil law tradition, which we get from Rome, filtered through the Spanish experience. So that is the hope that I ask you to entertain with me as we undergo these activities these past 3 days and this symbolic launching of this very little work, that we can be partners in hoping that the tree will grow, not just for academic purposes, that is a valid purpose, but I think more importantly, because that is one way in which we can serve our beloved country. Thank you very much.
Thank you very much, Professor Balane. May we invite the man in the book in front. Such an honor to be here right now. And I guess many of us had been relieved that the book is being launched just now. Imagine if we would have to take obligations and contracts under Professor Balane after he said that succession is peanuts. Whew, I guess that's how loud the applause was, Professor. Okay, so may I request, Blythe? May I request Deans Cedric Candelaria and Joey Hofelenia to receive the book to be given by Professor Balane to the Ateneo de Manila Law School.
With your kind indulgence, it is a symbolic gesture because the mandate that was given by the present this book as a token of the fact that I have fulfilled
And may I invite, Professor, you have two more. May I invite Dean Juan Jose Hinojosa Toralvo and Dean Gemma Tomas Martinez. Professor Pepin, yeah? Wala na si Justice. And Justice Ascuna, please. May I also request Vice President Jejomar Binay, please? There. Thank you very much. We now proceed to our closing ceremonies. May invite Professor Jose Manuel de Torres Perea, co-chairperson, or better known as Professor Peping. He likes the name that has been baptized to him here, to start our closing. He's the co-chairperson of the International Scientific Congress and an associate professor of civil law, University of Malaga, Faculty of Law. Your closing remarks, sir.
Thank you very much. Professor Balane, Decano Juan José Hinojosa, Decana Gemma Tomás, Dean Sefri Candelaria, Dean Joe Jofileña, Dean Dan Cordero Tan, Dean Nilo Divina, Dean José María Tirol, Lino, nephew of Balau, good friend, my Filipino and Spanish college. It's an honor to me to end this Congress, and when I was asked to do it, I thought in Pope Francis. When Pope Francis was in Manila, I remember he said, I want to buy through my heart. That is the reason Pope Francis decided not to speak in English. He decided to speak in Spanish with a translator in Manila, because he said, if I speak in English, I cannot speak with my heart. So he wanted to have the capacity of improvisation, and he could only to improvise, to have improvisation in English, in Spanish, not in English. That is the reason I decided now not to speak in Spanish, of course, but not to prepare anything for now, because I want to speak by heart, by improvisation. If not, we cannot speak by heart, if I read something, no at all. And the point is, why we are here in this Congress. Some of you heard me about this before, sorry, but I have to say. I think that the first guilty is Dean Hinojosa, here, from Malaga, is the first one. Because when I asked him 7 years ago, my Dean, we are in Malaga, Costa del Sol, this is a bilingual area, we must start teaching in English in our School of Law. Well, it was a surprise, but Dean Hinojosa said, yes, we must. Most of my college thought I was totally crazy to teach Spanish law in English. Why? What is the use? But with the support of Dean Hinojosa, I was able, and I started. I was crazy, yes, it was crazy to start, because you can take into account that no one book of Spanish civil law had been written in English before. Then I have to translate everything. And in this task to translate everything, I thought, maybe in Puerto Rico, maybe some place somebody has translated something from Spanish law to English. And I start looking for, in the internet, some test of Spanish law in English. And oh my God, I found Manresa in English. The comment, somebody who was speaking about Manresa in English, and he was repeating the test of Manresa in English. And I was totally surprised. I said, but Manresa never wrote in English. And Castan, I found Castan in English. Castan Tobeñas in English. His son, Castan Vasquez, was my professor in civil law. And then when I found that, I said, where is this from? Who is the one? And finally, I found my doctoral thesis is about Acción Pauliana, And then I found a decision in English that was word in English, but then appeared the word Acción Pauliana. And that's, okay, this decision cannot be from the States. And then I discovered, and I was totally surprised, that in spite of ignore one other during 50 years, we still are so close. And that when if I come here, I remember second time I come here, Professor Balane, I was having dinner, and he said, Jose, I want you tomorrow to teach to my students. Professor Balane, we are dining. The class is tomorrow. Yes. But I realized that is not a problem, because to teach the contract of sale is the same in Spain that in Philippines. We change only small things. So we are thinking from a legal point of view, Filipinos and Spanish are in the same schema. We are in the same sphere. So when I discovered that in Philippines, and the third thing is when I discovered the Filipino Civil Code in internet, and I realized that there are two articles. First article is the Filipino one, but the second one is the Spanish one. Then that is the reason I said, oh, what a good translation of the Spanish Civil Code. So, yes, because in the internet, the Ministerio de Justicia Spanish has a very bad translation, but this one is good. So, I thought, well, we have to contact them. Why we are not in contact? I don't understand. When that is a unique thing in the whole world. And that was when I discovered one book that is what the Spanish roots of Filipino law. And I said, oh, this is the book. The one who has written this book is the one I have to contact. And who was the one who wrote the book, Spanish Roots of Filipino, Rubén Balane. Then I know my task, my object, to contact Rubén Balane. And you think, well, contact him. So difficult. Because in Europe, our custom, if you enter in the web page of the university, each professor has a profile where you find his email. But in Philippines, when you enter in the web page, no email, no mail. So I know he is teaching in Ateneo, in other places, and I said, but nobody answered me. And at this time, I had another problem. The ambassador of Philippines came to Malaga, Charlie Salinas, to speak about the Typhoon Yolanda and what the students of the University of Malaga can do to help to our Philippine brothers. And in that moment, he went to the School of Law, invited by my dean, and I said, oh, it's perfect to prepare something. And then you remember the decision about the Filipino decision about the Pauliana action. When the ambassador came to my class, we were teaching Spanish law with this decision that was a Philippine decision. Then my ambassador, you can see we are teaching Spanish law with a Filipino decision. It's the same law. He was surprised, and he said, my president, oh, I want you to do a Congress, a Filipino-Spanish legal Congress. And my president said, okay, Torres, you have to do it. Well, I tried my best. But still, I had not been able to contact Professor Balane. Then the idea came, I said, maybe Professor Balane worked as a lawyer, as an attorney. If I try to find him in a legal office, oh, good idea. In 2 minutes, I contacted Professor Balane. No Professor Balane, but I found that he was working by a legal office, and these great friends from this legal office allowed me to contact to Professor Balane. Then they give me his email. And I write the first email to Professor Balane, and what he answered me was something like, sounds like the following. Oh, Professor Torres, I was waiting this email from 40 years ago. And don't worry. The Congress, when is the Congress? Well, 5 months, do you think? Don't worry, I prepare. And when I realized 4 deans of Philippine School of Law was coming to Malaga for the first Congress. That was incredible. We cannot believe what it was happening. And then and from the very first moment, we realized this special feeling we have when we are together that started when Professor Balane saw me in the airport, and the first thing he said, "You are Torres, Professor Torres?" Yes. Well, yeah, Assistant Professor Torres. Yes, I am. But you don't like Professor Torres. I am. You like Pepin. And from then, I am Pepin. That is the point. Well, that was the beginning. Then we had one congress, one convention in Malaga, and we were invited to here, to Ateneo first time, thanks to Selfrey Candelaria. What a level of hospitality in these islands. We were touched, totally touched, but with a big problem. What to do when you come back to Malaga in order to be at the same? It's impossible. I cannot imagine the problem that my dear Gemma Thomas has now. You try to explain this to the Deusto. Nobody understands. That only happens in. I have been as a visiting scholar in Germany, in United Kingdom. I was in Northwestern. I was in the University of Philadelphia. A lot of places. And from I came here, I only came here. And I said, why you don't go to other places? You have to go to Philippines. You understand this? There is no comparison. So, thank you. So, well, finally, we came here. Another convention was in Malaga. At the beginning, only 5 professors came here. Now we are 13. I am from San Estanislao de Cosca, Colegio de los Jesuitas de Málaga, the Jesuit. I was formed, I was 5 years by the Jesuits. And I went to the University of the Jesuits in Madrid, that is the Pontificia de Comillas, ICADE. And all my training is because of the Jesuits. So that is the reason we choose Ateneo, one of the reasons we choose Ateneo as the first. And that is one of the reasons at first we realized we need a partner like Deusto, that is the alma mater of the Jesuits in Spain, to be in this project. That is, makes sense to say, Deusto, come with us, share this project, because Ateneo must recover the link with Deusto. And that is another beautiful thing that we are getting now. So at the end, this is a dream. I know that Professor Balane is fulfilling last 2 minutes. Professor Balane is fulfilling a dream, also me. I am so happy to know somebody as Professor Balane. He's an inspiration. I would like to be like a little bit of Professor Balane sometime. It's impossible. Well, now the only thing I can say is Habemus Deusto. Nos vemos en Deusto. We'll see in Deusto. We are all waiting for you in Deusto, in Malaga too. Thank you very much.
Thank you, Professor Pepin. May I now call on the chairperson of the Legal Education Board, Honorable Emerson B. Akende, to give his closing remarks.
It's a good afternoon to everyone. And now I understand why I was given this very important part of the program, because I get to decide when we have lunch. In just a week's time, the Philippines will be celebrating the birth of the Republic and the overthrow of the Spanish colonial power from these islands 120 years ago. This time, however, let me assure our friends from Spain that you will not be chased away and will always be greeted with welcoming smiles wherever you go. Dean Sedfrey Candelaria, Dean Jose Maria Jofeleña, the incoming Dean of Ateneo Law School, Justice Adolf Ascuna, good morning, good afternoon. The former Vice President of the Philippines, Jejo Marbinay, our honored guests from the University of Malaga, led by Dean Hinojosa, and from De Gusto University, Dean Gemma Tomas, and the only dean who holds authority over me, the Dean of the UP College of Law, Dean Fides Tan Cordero, because I am in the faculty of the UP College of Law. And of course, special congratulations to my kababayan from Sorsogon, the revered Professor Ruben F. Balane. My wife shares the same hometown as he is, and I am also from the same region as he is from. And all honored guests who are present today. The Philippines and Spain have a strong bond founded on culture and history. While our intertwined past is both colorful and beautiful, it has also been at times tragic and affecting. Our relations are anchored in the lessons from the past, but we do not remain in it. It is an incredible story, then, that through the years, we have also been inspired to build between our countries a relationship that is, at the core, empowering for both. After all, the connection that we share has had, by all measure, deep and enduring impact on both our societies. Even as we mark today the end of this current undertaking, it also signals the continuing efforts towards more fruitful and transformative collaborations in the future. I am pleased that the fourth installment of the International Scientific Congress on Private Law of the Philippines and Spain has successfully tackled varying issues on today's most pressing concerns that affect our democratic way of life. There are monumental changes, for example, being proposed that promise to overhaul the Philippine Republic, and it is laudable that some of the discussants have precisely focused their attention on this. Notable as well are the discussions that tackled emerging and pressing concerns on liberties, health services, and business as we contend with advances in technology. As chairman of the Legal Education Board, I take particular interest on the discussions on legal education and will seek to draw lessons from it. All of these legal knowledge and academic conferences like these that produce them are valuable to us in the Legal Education Board. Legal scholarship is, after all, one of the pillars of our legal education, and under our laws, we must be able to form lawyers who are steeped in the best traditions of legal research, analysis, and articulation. I am happy to note that some of our presenters here showcase the research that they accomplished as students. Yet the truth is we must do more in pushing for better legal scholarship among our students, professors, and legal practitioners. There is still much to be done or to be desired in the field of legal research and writing. Our universities and faculties of law are simply not producing enough despite the increasing complexities of law and society. The scientific discussions here in the past days offer proof of the potential of legal scholarship, but we have only scratched the proverbial surface of a world of legal education that assists the bar and the bench and the broader society on matters of the law, its pitfalls and intricacies, as well as its beauty. While this responsibility to research and educate can sometimes be challenging given the limited resources and time demands of our daily preoccupations, I am sure we do not lack passionate, talented, and ready individuals in this room who will be partners of the LEB in realizing even higher qualities of erudition in the law. On behalf of the Legal Education Board, I believe congratulations and thanks are in order. First and biggest congratulations to the Ateneo de Manila University School of Law and the organizing committee led by Dean Candelaria for a wonderful job of hosting our guests and participants. The Ateneo Law School continues to be a steady partner and pioneer in legal education. I would also like to extend my gratitude to the other collaborators of this endeavor, the University of Malaga, the Philippine Association of Law Schools, the Gusto University, and the Embassy of Spain in the Philippines. I thank all our presenters and moderators from across the Philippines, Spain, and other parts of the world who have made the journey here and have ably led the discussions. Before we formally close this event, let me take a moment to appreciate the seminal work being done here in this conference as legal experts from both Spain and the Philippines come together. I can only imagine the wider repercussions of this initiative to legal scholarship and the development of civil law. Nonetheless, there is a challenge to us all here present today, and that is to continue this robust interaction between our countries. Perhaps, again, the 5th edition of this will be taken care of by Piping again, Professor Piping. There is always a criticism hurled at educators and scholars who gather in these types of events. We remain a talk shop, trapped in the ivory towers of the academia. So I challenge everyone to make sure the discussions here find their way to the new books and literature we publish, to the lectures in our halls, and to the collective knowledge of the broader legal communities we serve. In fact, if there is boldness in your heart, let our learnings here also move us to extend real-world impact on our immediate societies, and let it motivate us to be more vocal and active as the currents sweeping the world continue to shape our nations. Thank you once again. Mabuhay ang Pilipinas, mabuhay ang Espanya. Now we can have lunch.
Thank you very much, Chairperson Akende. Before we break off to lunch, Dean Candelaria would just like to give some tokens to our Spanish partners. May I call on Dean Hinojosa Toralvo, Dean Tomas Martinez, Dr. Rodriguez, and Professor Piping to receive the token from Dean Cedfrey Candelaria. And final announcement before we break off for lunch, or before we conclude for lunch, may I request the representatives of the organizers of Ateneo de Manila University School of Law, the University of Malaga, Faculty of Law, University of Deusto, Faculty of Law, representatives from the Philippine Association of Law Schools, as well as the Embassy of Spain, and the Legal Education Board for a group photo here in front. And while they are having the group photo, this concludes our 4th International Scientific Congress on Private Law of the Philippines and Spain. Thank you very much for attending and participating. Have a healthy lunch. Thank you.